Then, ordinary promotions, item number 1.
For reasons mentioned in the judgment, this writ appeal is dismissed.
May I please lordship, my lord, item number 6, hearing. My lord, I took the consent of the opposite party, may be fixed after 4 weeks, my lord. MFA.
Heard Mr. R.C. Paul, the learned counsel for the appellant, who prays for an adjournment due to personal difficulty. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the same. Stop. Hence, the prayer is allowed. Let this matter be listed after 4 weeks.
My lord, nothing, my lord, supplementary item number 24 orders. It has to come in the hearing list, hearing column. 24th.
You have informed the other side.
Yes, my lord, he is here. Fixed on, my lord, 22nd of September. If, my lord.
Heard Mr. R.C. Paul,
He also present by the opposite party.
I am for the 11 of.
learned counsel for the appellant. Also heard Mr. S.I. Akand, the learned counsel for respondent / claimant. It is submitted at bar that this appeal is ready for hearing. Hence, it may be listed for hearing.
22nd of September, if
Let this matter be listed
22nd of
on
September.
22nd of September.
Much of
May I please, Lordship. Lordship, I beg to mention item number 20, Lordship, the full consent of the respondent side, Lordship. Pray for adjournment, Lordship.
Lordship, I am for respondent number 3.
What is your name?
A. Datta on behalf of A. Ganguly, Lordship.
Heard Mr. A. Datta appearing on behalf of Mr. A. Ganguly, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. Also heard Ms. P. Thakur, the learned counsel for respondent number 3, who does not raise any objection. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a
Deeply
date to be fixed by registry.
May it please your Lordship. Your Lordship, with due consent from other side, I beg to mention item number 22 of today's list, your Lordship. Your Lordship, conducting counsel has some personal difficulty, your Lordship.
Heard Ms. P. Thakur, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
Oblige, your
May please your Lordship. Lordship, in item number 15, seek adjournment for the day, Lordship. 5 seconds.
Heard Ms. P. Hujuri, the learned counsel for the
Apple.
appellant, who prays for an adjournment on the ground of personal difficulty. She submits that she has informed learned counsel for the other side regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks.
Lordship, with the consent from the other side, Lordship, I beg to mention item number 19. Matter will be adjourned for the day, Lordship, and fixed on 10th of September, Lordship.
You cannot have choice. You make one prayer, either adjournment or choice of date.
Fix on 10. I have no difficulty.
Item number?
19.
What is your name?
Lordship K. Bharali.
Heard Miss K. Bharali, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. P. Hajorika, learned counsel for the respondent, who does not oppose the prayer, hence the prayer is allowed. Let this matter be listed on
10th of September.
10th of September.
Deeply obliged.
Wait, please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item number 11, Lordship. We are for respondent number 4 in this case. Due to some personal difficulties, conducting counsel won't be able to conduct this.
You have informed the other side.
Please for the.
Heard Miss M. Soikia, learned counsel for the respondent, who prays for an adjournment due to personal difficulty of the conducting counsel for the respondent. Mr. A. R. Agarwala, the learned counsel for the appellant, does not raise any objection. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on the date to be
Obliged,
fixed.
Lordship.
May it please your lordship. Also, I beg to mention item 21, hearing matter, lordship. This will kindly adjourn the matter for today on lordship.
Heard Miss. What is her name?
K. Malakar, lordship.
Heard Miss Kim. You are for the appellant.
No, lordship, I am for the respondent, lordship.
Heard Miss K. Malakar, learned counsel for. You have informed the.
No, lordship, I have not the number actually, lordship.
Then you have to wait. Then we will adjourn it when the matter. I am marking it. We will adjourn it when the matter is called.
Yes, lordship, yes. I am obliged, lordship.
May it please your lordship. I beg to mention item number 16. I have taken consent from the other side. And I have also submitted adjournment request yesterday. There is some difficulty on the part of the conducting counsel.
Heard Mr.
B.J. Talukdar on behalf of
B.J. Talukdar,
Mr. D. Das.
appearing on behalf of Mr. D. Das, learned counsel for the respondent.
Number 2.
Number 2, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks.
Blessed.
May I plead to Lordship, with the consent of the other side, I beg to mention item number 9. My senior SK media is not well. He is suffering from fever.
Heard Miss
R. Datta.
R. Datta, learned counsel for the appellant, who prays for an adjournment on the ground that the conducting counsel for the appellant is indisposed. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks.
Wait, please, your lordship. Your lordship, I beg to mention item number 7 and 8. Taking consent from the other side, I'd like to adjourn the matter for the day as the contending counsel is out of station.
Heard Mr.
A. Dev,
A.
on
Dev,
behalf of D. Rathi.
A. Dev, appearing on behalf of Mr. D. Rathi, learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. He submits that he has informed the appellant regarding his prayer for adjournment, who does not have any objection to the
Lordship,
same.
the appellant is present.
What is her name?
Sharma.
Miss S. Sharma.
Mr. B. Sharma, Lordship.
Appearing on behalf of Miss B. Sharma, learned counsel for the appellant, does not raise any objection. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by the
Your
minister.
lordship, what date it may be fixed? It's a 2011 matter, your lordship.
After
long.
4 weeks.
Much of-
May it please your lordship. I beg to mention item number 17 for today's costly hearing is costly.
Yes.
Lordship, as my senior is for her due to her personal inconvenience, she would
What is her name?
M. Chaudhary.
Heard Miss M. Chaudhary.
Her SK Begum.
Heard Miss S.K. Begum. You are appearing for
Oriental Insurance Company, appellant.
appellant. Heard Miss S.K. Begum, learned counsel for the appellant who read for an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks.
The order magistrate.
If you might guess. Okay.
Maybe Lordship, Lordship.
Yes.
Lordship, I have put a respondent, Lordship, respondent number 1, Lordship. Lordship, the respondent number already died, Lordship. One last month I have received the information from the wife of the respondent. I have submitted the death certificate and next of kin certificate. My lord. But there was no any communication with the client. Lordship, so I came on the last one. So when I actually, Lordship, this matter has been settled outside the court in with the insurance company. Hereafter, when I informed the respondent number 1 claimant, coming and saying local adalat for next local adalat Lordship. Then the family member informed him that he was already there. So Lordship will be allowed to and include the name of the legal guardian. Either will be settled and saying next local adalat.
But appellant is absent. Who is?
I already wasn't there, Lordship.
Okay.
I-
You inform her.
Yes, yes.
We'll fix it on a.
Actually, I saw him the if she Lordship.
None has appeared for the appellant on call.
Lordship, what sort of time being
No,
Lordship?
no,
I saw him.
no, I will mention it. None has appeared for appellant on call. Mr. D. Kolita. Oh, your name is D.
DK Kolita.
Mr. D.K. Kolita appears for
Respondent number 1.
respondent number 1 and submits that the respondent number 1 has died, has expired on 17/2/2024. And in support of his submissions, he has produced a copy of death certificate of respondent number 1. This I can keep in the record.
Yes, Lordship. And
The
next of kin certificate was also submitted, Lordship. On the
he,
next.
he has also submitted a copy of next of kin certificate of the deceased respondent number 1. Let these let these said certificates be kept in, be marked as X and X1 and be kept in the record as part of it. In view of the death of respondent number 1, the appellant is directed to take appropriate steps for substituting the legal heirs of the deceased respondents. Let this matter be listed.
Lordship, you kindly give the first week of the September, Lordship. Because
First week
Second.
September.
Saturday,
2nd of September.
Also,
Report.
May it please your lordship.
Yes.
This is that review application, my lord. Wherein the suit was for eviction of tenancy on the grounds of bona fide. And the suit was decreed, it was upheld by the appellate court as well as by the revision court itself. And at the time when the review petition was moved, this honorable court considered the fact that material exhibits were not considered by the trial court, appellate, either of the courts, my lord. And that is how this honorable court, being satisfied, was pleased to stay the execution proceedings.
Where is the stay order?
Yes, notices have been served. And the other side is appearing.
No satisfaction as you are submitting. No such
For the purpose of, no, today it is listed for orders.
orders. It has to be disposed of in the orders column.
My lord, I'll place the same, my lord. My lord, if my lords may see,
The execution was stayed because the execution case was proceeding.
that's right.
That was your submission.
Yes, correct. At page 225, the rent receipts. Page 225.
Yes.
225, the rent receipt, this honorable court may kindly notice that it is by Sujaudin, the plaintiff, and my lord may kindly notice the signature of the plaintiff on the rent receipt. So this is the receipt issued by the plaintiff. Because our plea was that he is not the absolute owner and it's a joint property and the plaintiff could not have.
No, where is the defect in the order and judgment under review?
I'll point out, my lord. And then let us go to the electricity bills. At page 276. There are typed copies, but I'm taking my lord to page 276. This is exhibit Z20. From exhibit Z20 onwards, these exhibits were produced by the defendant. And this exhibit, the whole series of these exhibits, this my lord may kindly notice the signature here at page 276. This is the other brother who is not made a party to the suit. And although we had raised a specific plea of non-joinder of necessary parties, and we had also exhibited that it was the whole rent of the premises was bifurcated. One brother would collect of the space and the other essentials, the water, the electricity would be collected by the second brother. It was a joint property. There is a plea by the plaintiff that there was partition and the tenanted premises went to the plaintiff. But other than the oral submission, there was no partition deed or any documentary evidence led. Now, the oral evidence is also evidence, but if there is oral evidence and the defendant has produced documentary evidence to show that the rent also would be collected collectively by the two brothers, and these exhibits not being discussed at all, whether this
this material evidence being left out, which according to me, my lord, in my humble submission, was a material irregularity, a material defect in consideration of the evidence, which led to the conclusion that the learned trial court or the appellate court or the higher court arrived at. In absence of this, the judgment seems to be very correct. But if we take this, then we see that the issue on non-joinder of parties and the bona fide requirement by one of the brother becomes highly questionable. And in my submission, this defect, it is Z20 pa kemana se series to? It is from Z20. Z20 to Z47. 27 exhibits. This 27 exhibits is not at all discussed by any of the court. This is my primary ground of review.
What these exhibits indicate?
My lord?
What these exhibits indicates?
These exhibits indicate that the plaintiff alone was not the absolute owner of the property and there was no authorization. The other brother was not even brought as a witness. There is nothing from the other side, and whereas
No, whether
the-
you are taking these pleas for the first time
it,
in the review application.
we have taken this plea on the issue of non-joinder of parties. That we have said that
Let us see. Let us see. Let us see.
Let us take the WS. WS page number.
No, then how the judgment under review is defective? On what count?
My lord, when the material exhibits is not considered at all, judgment criteria, when the material exhibits is not considered at all, in that case, a material defect arises because a part of the evidence is not considered at all and it is left out. If that is taken into evidence, then the issue of a non-joinder of parties, it would have reversed perhaps.
You are making this submission for the first time.
My
Before
lord,
during the hearing of the revision petition, no such submissions was made.
my lord, that is what I am saying, that when we are in a revision or a review, we are in a limited confines. And the fact that at any stage, if it has come to the notice that material exhibits were left out, which would have a material bearing on the conclusion as to how the issues were decided, that non-joinder of parties, that bona fide requirement, if it's a joint property,
No, listen to.
my lord.
While dealing a revision, the jurisdiction of this court is a very limited jurisdiction.
Correct.
It cannot go into
Correct.
reappreciating evidence.
Correct.
Still, you did not point it out while arguing the revision petition. This submission is for the first time. This submission could have been made while you argued the revision application.
Perhaps, my lord, I would just point out one thing, my lord. I am not raising an issue of to reappreciate the evidence, that this is the evidence, it was appreciated this way, it should be appreciated this way. I am not on the plea that let the evidence be reappreciated. The conclusion arrived at by discussing the evidence is not correct. And this is not my argument. My argument is that there are material exhibits having a direct bearing on the issues that have been decided, whether this honorable court, even if it is at the stage of review, whether this honorable court is empowered to consider this fact that a series of material evidence has been totally ignored. It's not a question that it has been decided and there is a finding. Then perhaps I would have taken my seat, my lord. But it is something that is going to the root of the issue and has.
And you forgot to argue on that point while you arguing revision petition.
My
And
lord,
you remembered later on, therefore you filed a review application.
my lord, I'm not aware about what the oral argument was, but at least from records it appears that this fact was not noticed by any of the courts, or for some reason it was just ignored by all the courts at the time of the suit.
Whether you pointed it in your appeal, in your revision, or your first time pointing it out in review. Even we are not going into question whether the evidence which you are indicating have some relevance or not. On that, I'm not making any observation. I'm only putting query. Even if assuming that it has some relevance, did you pointed it out in your appeal? Then thereafter in your revision, did you pointed it out? Or for the first time you are pointing it out in your review application?
And let I get the query. My lord, as I mentioned, my lord, there is no specific pointer either in the appellate, before the appellate court or the revisional court about these exhibits. But in my respectful submission, when the suit was tried, it was incumbent upon the trial court to consider all material that was placed before that honorable court.
No,
Now-
is it your submission that these exhibits indicates that the rent was collected by one brother and electricity was collected by another brother? Therefore, they were in joint possession.
Not therefore, they were in joint possession. This is a supporting fact to reinforce my plea that they are joint owners. But the plaintiff's plea that they had partitioned, other than the oral evidence, neither the other joint owners was brought as witness, or neither any partition deed was produced. Now, in that background,
Who is the other joint owner you are referring to?
that is Saduddin, na? Saduddin. My Saduddin.
Who used to collect electricity dues?
The electricity and water charges, all other amenities was collected by the brother, Saduddin.
Therefore, your submission is?
Therefore, my submission is that the trial court also failed to consider these material exhibits, and it went on, perhaps if I may say, a little bit of an emotional bargain, as though that, okay, this property does not belong to the tenant, of course. It belongs to the landlord, so landlord has we are aware of that. That is why this suit, and that is why we pay the rent. I am not, and we also brought into evidence that the issue actually arose out of a hike in the rent. It was a spike, in fact, not a hike. It was a spike in the rent. If it was a gradual increase, then also perhaps it could have been done. And when the spike was so much and the landlord did not want to consider that, and this is how we filed the suit first. And that suit was in our favor, but said that when there is any lawful process done, they can be of course evicted. That was the suit that was in our favor. And thereafter this suit came in. And so far as the bona fide requirement is concerned, my lord, the property is such they have a big property and all premises are rented out. And if I may give a statement here, my lord, at the bar, my lord, that if there is a gradual increase by 10% or 50%, 15%, any reasonable increase, I am ready to pay that rent, because normally in 1 year, 2 years, 3 years, there is a hike in rent. But there was such a spike that for us also it was like taking advantage of the fact that we cannot do without the go down, because we have a shop just across the road, and unless we have a place to keep the goods, we cannot operate the shop. Now, so far as that part is concerned, that is the other part, my lord. But the fact remains that it's a joint property, except the oral evidence that it was partitioned. There is no other evidence, and against that, we have documentary evidence which was exhibited, which was proved, saying that, and if I may just take my lord, till the time, till the time they had given a notice, etc., at page 303, this continued. So when did the partition happen? There is nothing except for saying that, and it was believed. On what basis it was believed when there is documentary evidence to show? And wait, 2013, a notice to get here to say. 2013, the suit was filed, and at 303 in 2015, the brother continues to collect the rent. So what was it during the suit, during the trial there was partition? If there was any such partition, you could have placed it before the court. In my respectful submission, this question that this honorable court has put, I need to answer that. But at the same time, whether the trial court should have, ought to have, it had to exercise its jurisdiction on all the material that was placed before the court. The trial court took into consideration and discussed at length the oral evidence, while there is not even a mention about the exhibits. Perhaps that is why in the appeal or in the revision, this part was not specifically taken, but the issue of non-joiner of necessary party was definitely taken before all the courts. And these are materials to support the issues that were raised. And as we know, my lord, I need not trouble my lord with this, that documentary evidence will always have it will have more value than oral evidence. Except the oral evidence, and the brother does not come and give evidence that yes, there was partition. And he was an interested witness who said that there was partition and this is my property. On what basis you say this is my property? Because it's a whole massive big building. So whether one room was given to you and one floor was given to you, which part of it? There are many brothers and sisters. In my respectful submission, this was a triable issue which the learned trial court, if I may say, failed, ignored that material exhibits, and therefore this opportunity should be made available and granted for reconsideration. That's my humble submission. And so far as the rent is concerned, this I make a statement at the bar that if it is a reasonable 10% hike, normally which is that I'm ready to do that. I do not want to deprive the landlord of his dues, because I know that the landlord will not do any business. They will rent out, will get a little higher rent. So I'm ready to pay that. And in the meantime, I'm not saying that this issue be closed. Let the issue remain open. In the meantime, I will continue to do that while the while this issue is reconsidered and decided. I am trying to be fair as possible, and I leave it to this honorable court, but just at the cost of reiteration, there was evidence which would have a total bearing, a reverse impact on the whole conclusion that has been arrived at. And just to say that the review has a limited power. Yes, I am aware of that. And in fact, that is why I am taking this plea. I'm not saying that to reappreciate. No evidence needs to be reappreciated what has been appreciated already. But what has not been appreciated, that needs to be appreciated. That, in my respectful submission, is a defect which needs to be corrected and rectified even in the exercise of powers of review. That's my humble submission, and I'm grateful, my.
My lord, my very first submission would be that, my lord, for a review, my lord, there has to be a mistake or error apparent on the face of the record in the judgment, my lord. That part is not there. So for correction, it is open, my lord. But if there are two views, the honorable court or the trial court or the appellate court would have taken, my lord, in that case, review is not maintained. If two views would have been taken, my lord. So, my lord, in order to have a review, my lord, the first part is that they must show some.
Where is the trial court's judgment?
My lord, the trial court judgment. Just it starts from page 78, my lord. Now, for a moment, my lord, would kindly come to page 109, my lord. The submission which the learned senior colleague was placing, my lord, 109. The appellate court judgment, my lord. The contention of non-joint or a party is that the brother was not made a party. That was dealt with in the judgment.
10?
109, my lord. The judgment of the appellate court starts from page 105. The relevant part is at 109, my lord. Para 5.
Yes.
Para 5, my lord.
Yes.
The defendant contesting this suit and filed a written statement against the plaintiff of the plaintiff. The defendant has categorically denied all the averment made in the plaintiff by the plaintiff, stating that there is no cause of action for filing a suit is bad for non-joint or necessary parties, such as Muhammad Salahuddin Ahmad, the brother. That the defendant states that the plaintiff has violated the law relating to this by demanding exorbitant from the defendant when he refused to go down to the so and so. Then last three lines, the plaintiff has stated he completely unaware of any kind of agreement regarding the suit premises executed between the plaintiff and his brother Salahuddin. So this aspect was already argued. Now my lord would appreciate, they don't deny that the agreement is with me. They don't deny that in the same building my brother and me both are staying together, my lord. Since my lord, the electricity meter was joint, my lord, that is why the portion of electricity consumed by this, my lord, was taken. Because he was paying. I was also contributing to that, my lord. It was a common, my lord. So, my lord, this is nothing but only a receipt of an electricity which was consumed by the tenant, my lord, and which was paid, my lord. That apart, my lord, would kindly see the rent receipt, the challans which are deposited in the court, my lord. My lord would kindly come for a moment to page 238, my lord. 238. The rent deposited in the court, my lord. The challans. There are numerous challans. I am only showing one, 238, my lord. Kindly see. Assam Trade Agencies against Sujauddin Ahmed. So where is the question of asking the other brother once they themselves admit that, yes, he is my landlord? They could have deposited the rent in the name of the brother along with me had they taken that plea, my lord. All along, my lord, all these years till today, my lord, starting from 2012 to 2026, they have been reporting the rent in my name, my lord. Sujauddin Ahmed, my lord. Now, as my lord has thought the query, my lord, the trial court judgment is at page 78. It starts from page 78.
What else is your submission?
Second submission is that, my lord, the non-joinder submissions which they have placed on record, the ground is missing in the review application. Now, my lord's judgment, I'll just take your lordship. The first ground they have taken in the review application is that I have not obtained any trade license. So, my preparation is not at all there for initiating a business, my lord. Till I don't have a shop, my lord. How can I take a trade license? Because the GMC authorities are going to see the shops, my lord. This is also taken care of by your lordship judgment, my lord. At page 223, this honorable court has passed the judgment. My lord, at page 323 in the judgment, para 15, lordship has taken note of this. Then the bona fide requirement, existence, genuine, honest and bona fide requirement is also taken by your lordship judgment in para 12, page 322, my lord. Then, my lord, exorbitant rent, demand of compensation, disconnection of water supply, your lordship has taken care of the said aspect in page 320 of the judgment passed by your lordship. So, my lord, all the points, my lord, yesterday I have thoroughly gone through an entire grounds which have been taken in the review have been dealt by your lordship in the judgment. Now, I'll just place three judgments of the Honorable Supreme Court, wherein, my lord, the review can only be on a limited corner, my lord. I'm just placing, my lord. First is S. Madhusudan Reddy versus V. Narayana Reddy. Well, para 26, my lord. Internal page 65, my lord. As can be
Yes.
seen from the above exposition of law, it has been consistently held by this court in several pronouncements that the court's jurisdiction of review is not the same as that of an appeal. A judgment can be open to review if there is a mistake or an error apparent on the face of the record. But an error that has to be deleted by a process of reasoning cannot be described as an error apparent on the face of the record. For the court to exercise its power of review under Order 47, Rule 1, in the guise of exercising power of review, the court can correct a mistake, but not substitute the view taken earlier merely because there is a possibility of taking two views in a matter. A judgment may also be open to review when any new or important matter of evidence has emerged after passing of the judgment, subject to the condition that such evidence was not within the knowledge of the party seeking review or could not be produced by it when the order was made despite undertaking an exercise of due diligence. There is a clear distinction between an erroneous decision as against an error apparent on the face of the record. An erroneous decision can be corrected by the superior court. However, an error apparent on the face of the record can only be corrected by the exercising the jurisdiction. So, my lord, here, my lord, they could not place any such point before your lordship to show that your lordship can entertain the review application. Then, my lord, the second judgment, I'll not, my lord, I'll just place the judgments, my lord, because all are on the very same point. But, my lord, the concurrent bench of this honorable court, my lord, passed a judgment in, my lord, Renu Devi Kucheria versus Triveni Devi Tewari, my lord. In that, my lord, the entire judgments of the review aspect has been dealt with, my lord. All Supreme Court judgments have been dealt with, my lord. Starting from para, I'll just point out your lordship. It starts from para.
26, I think.
It starts from para 21, my lord. From para 20, my lord. From para 20, my lord. Thereafter, my lord, all the judgments, the case of Raja Prithvi Chand, my lord, Patel Narasit, Northeastern Caterers, my lord, Meera Bhanja, Surjit Singh, Board of Control for Cricket in India, all these judgments have been referred and taken care of by this honorable court, my lord. And, my lord, a reason order has been passed why review cannot be entertained, my lord. The entire judgments have been quoted and placed, my lord. So I will not take any more time of this honorable court.
My lord, I may just point out, so far as the judgments are concerned, in fact, I'm grateful to my friend because they helped me. Now, the first Supreme Court judgment that has been placed, it says that where two views are possible. This comes when I am seeking reappreciation of evidence. And the said judgment, Supreme Court judgment also says it can be exercised when there is an error apparent on the face of the record. Now, this is what I point out, that Z20 to Z47 has not been considered at all, is something which is on the face of the record. They are already there. There is no discussion on that. No conclusion arrived at on the exhibits, nothing. And so far as that High Court judgment is concerned, that's a concurrent judgment, it says, and the judgments will have just placed with the person. And the judgment that has been considered by this honorable court. Yeah. Paragraph 22. That the revisional jurisdiction of the High Court under so-and-so cannot be equated with the power of the first appellate court. He submits that in exercise of revisional jurisdiction, the court cannot reappreciate the evidence. Exactly, that is my case. I'm not seeking this honorable court to reappreciate any evidence. There is a clear bifurcation of what I am seeking and the judgments which my learned friend has sought for. I'm not asking for reappreciation. I am aware of the limitation in the review petition. And the judgments which have been said, what does it say? At
What you are asking?
paragraph 25.
What you are asking for?
What I am asking for, that the exhibits were not considered at all is an error apparent on the face of the record. I am not seeking that these exhibits were considered, this view was not possible, this view should have been taken. I'm not arguing on that. That is why I did not place all that, all this, what my learned friend is placing. What I am asking is, my learned friend also could not show that these exhibits were considered. If it was considered, my lord, I will not detain this honorable court further. So far as that, go to page 4, you select.
This one, 87.
Page 187, paragraph 4. I say that as per the information given by the plaintiff, there are others also, but I'm just speaking out one paragraph. The plaintiffs claim to be the absolute owner of RCC building and the land mentioned in the plaint, which is covered by such and such. And it is the plaintiff, this is the information given by this is a claim of the plaintiff that we are stating. And it is the plaintiff who has been collecting the rent from the defendant firm in respect of the suit premises, and hence the plaintiff is a landlord in respect of the suit premises. However, I have no knowledge about the alleged partition said to have been taken place between the plaintiff and his brother Salahuddin Ahmed as stated in the plea. It would be worth mentioning here that though the rent in respect of the suit premises is collected by the plaintiff, but the electricity charges in respect of the same premises is being collected by the defendant firm by his brother Muhammad Salahuddin. I am here to state that myself is completely unaware of the internal agreement, if any, between the plaintiff and his brother Salahuddin. Until date, neither the plaintiff nor his brother has come forward and clarified regarding the matter. But considering the facts and circumstances of the case, Muhammad Salahuddin is a necessary party of the suit, but as the plaintiff has not been implemented has not implemented him, the suit, the plaintiff is defective and is liable to be dismissed. We have taken this, and there is no cross-examination on this. On the
Are you claiming Salahuddin to be your landlord?
there is no admission that the plaintiff is my landlord, but yes, the agreement not at the time when the suit was filed. The previous agreement was signed by the plaintiff, but there was an arrangement that part of it will go to the one brother and part of it, so far as the usage is concerned, will go to the other brother, and these material exhibits support this plea.
Where was that arrangement?
That arrangement was a oral arrangement, and this is supposed.
Where is the evidence that
These exhibits Z20 to Z47, all the water bill and the electricity
No.
charges.
it only shows that Salahuddin collected, but where is that evidence that there was such an arrangement
That there was such an arrangement.
between
That I
the-
made oral evidence, and the fact that all throughout the electricity bill and the water charges has been collected by the other brother, and even the plaintiff or the other brother.
No, in para
If
4 of your written statement,
Yes,
you never claimed that the other brother is also your landlord.
my lord,
You only claimed that he used to collect electricity rate.
my lord, before I'm grateful to the question, my lord. I am not saying that these two are the landlords. It's a joint property. It has never been partitioned. It's a family property. There are brothers and sisters, and none of them except Sujauddin has.
Who is your landlord?
My lord, as I said, it's an ancestral property.
No, that is not my query.
My lord,
My query is who is your landlord to whom you were paying rent?
I was paying rent to both the brothers.
But your deposit in court does not indicate that.
It continues to be. It continues thereafter even till.
No, you show any statement.
My lord, page 78 for a moment taken.
My lord, I may also point out one thing, my lord. So far as collection of rent is concerned, there may be any agency collecting the rent. By that, does it confer title? When a plaintiff institutes a suit saying that it is his property, the plaintiff has the onus to first prove that he is the owner of the property. We are not disputing the fact that there was a tenancy agreement. It's a joint property. One of them was authorized to execute the tenancy agreement. It has been executed. There is nowhere in the evidence that he is the absolute property other than the oral evidence saying that there was partition.
No, my query is, have you denied the fact that the present respondent was your landlord?
Yes, I have denied
My lord,
this in the
page 78
WS.
will clarify it. Page 78.
Okay.
This suit
Wait.
filed by them against this landlord not to evict without following the due process of law. Page 78, my lord.
Yes.
Their suit, my lord.
That has been mentioned in the judgment under review.
There also they say that yes, he is my landlord. He wants me to evict without following the due process of law. That was decreed. Nowhere they say that it is allowed in the other brother who is also my landlord. Nothing.
My lord, page 81, paragraph 5. Page 81, paragraph 5, the defendant's version.
Yes.
The second sentence, my lord, first, second, third, fourth line, that after expiry of tenancy agreement on August 2012, the plaintiff is not a tenant of the rented premises under the landlordship of the defendant. This is the case of the defendant in my suit. He is saying that plaintiff is not a tenant of the rented premises under the landlordship of the tenant. After 2012, there has been no written agreement. And I do not say that he is the owner of the property. It's a joint property. And this is an admitted fact by the defendant, who is the plaintiff, in which I am seeking review now.
Okay. Anything else?
And in my respectful submission, my lord, all said and done, in my respectful submission, the fact remains that it was collected by two of the brothers. The fact that the exhibits were part of the records, and none of the courts has, at least the trial court, if I may say, the trial court had the duty to discuss the complete evidence before the honorable trial court, which the learned trial court has failed to exercise its jurisdiction. And as the matter traveled to the, and my lord, I may say one thing, as I said, if we see the trial court without considering the exhibits which has been ignored, it appears to be a judgment which need not be interfered with. That is why I'm taking this at the time of review also, that if we just do not go by the other things that are on record and we just see the trial court record, it appears to be there could have been a second view, that's a totally another thing, but it does not really make out a case for revision. And this honorable court will very rightly dismiss the revision. But when this fact has been brought to the notice of this honorable court, that there was glaring material evidence which was totally ignored.
Okay.
I leave it to this honorable court, my lord, but in my respectful submission, at least this fact having been pointed out, and even the Supreme Court decision says that if some material fact has been ignored, review will lie. Even that Supreme Court judgment which my learned friend has placed, that if you have material fact which did not come to the notice, and I have a better case, I'm not coming up with new evidence. I'm just pointing out that the evidence which was already there was not noticed by any of the court. And I rest my case, my lord. I leave it to this honorable court. I'm grateful, my lord.
Miss B.S. Goel, the learned counsel for the review petitioner. Also heard Mr. A. Tiwari, the learned counsel for the respondent. Hearing concluded, judgment reserved. The stay on further proceeding of title execution case number 14/2026 shall continue till delivery of the judgment in this review petition.
Deeply obliged, Lord.
I'm grateful, my lord.
Five.
May it please your lordship. Lordship, as per last order of this honorable court, the honorable registrar has put a flag which is marked as flag X regarding the track consignment of the service which we have taken steps, my lord. The second page of the track consignment shows
The notice was received by the contemner on 18/6/2026, my lord. 18/6/2026. In that view, service may be considered as complete, my lord.
What you have alleged?
My lord, the petitioner is the father of a 3-year-old daughter, my lord. The family court as well as this honorable court has given a visitation right to the father. But in spite of the order passed by 2 courts, lordship, the contemner is not allowing the father to meet with the daughter. And the contemner's family also tried to give the child in adoption. To that effect, lordship, we have also lost an FIR with the local police station that is also annexed in the contempt petition, my lord. In spite of the order of this honorable court that is in present of their counsel, they have agreed that they will allow the father to meet with the child, but they are not allowing the father to meet with the child, my lord. And the situation is reached to the point that the child unable to recognize the father as well, my lord. My lord, some other issues also arise, lordship. The mother also tried to change the name of the father, but with the intervention of the deputy commissioner of the district, my lord, it has been stopped. So matter is
Whether FAO record is there? Echo record there. Heard Mr. R. Karim, the learned counsel for the petitioner. On perusal of the postal track consignment report of notice issued to the respondent, respondent by speed post, it appears that the notice was delivered to the addressee on 18/6/2026. In view of above, the notice has been held to be duly served on the contemner. Stop. In this contempt petition, the petitioner has alleged willful and deliberate violation of the direction issued by this court on 1/4/2026 in FAO number 3/2026. What is the status of this FAO?
it is pending, lordship. They were supposed to file affidavit in opposition, yet not. They have not filed yet.
Hence, let this matter be listed along with the concern, along with the FAO number 3/2026 on 11 September.
Can it be in the next week, my lord? Since father is not able to meet with the child since last 20 months, my lord.
You can wait for some more day.
Oblige, lordship. Oblige.
11%.
Bishop, I think what?
Made teacher also. And let the succession certificate was granted in favor of the petitioner, my lord. That was set aside on the basis of an application filed by the opposite party. My lord, the opposite.
By the trial court.
By the trial court. My lord, the petitioner and opposite party has brother and sister. The opposite party is the married sister. My lord, their father executed a will. My lord, she was not given the property. All the properties were given to his sons, this petition number 1 and 2. My lord, we accordingly filed succession certificate that was granted. Against that, subsequently she arrived and she filed an application, my lord, for setting aside. That was satisfied.
Succession certificate was granted on the basis of will.
No, not will, my lord. It is the fact, my lord. And thereafter, my lord, she filed an application that she was not made party surreptitiously, and so, my lord, the succession certificate was set aside. My lord, kindly come to page 13. This is the copy of the will, my lord. At paragraph 4, my lord. And whereas at present I am residing with my sons who are looking after me, and my only daughter got married long time ago and she has been living happily in her matrimonial home, and I have already gifted her money in the form of FD and insurance policies along with valuable jewelries. So I have decided not to give her any share in the scheduled property. This is the will, my lord. So my lord, she was not made party. My lord, then my lord, in succession case, my lord, she was not made party. My lord, then you also come to page 17, my lord, annexure 2. This is the section certificate which was allowed by the learned additional district judge Tinsukia. Then, my lord, page 43, my lord, her application. 43. Now, should kindly see. A petition under order 9 rule 13 CPC read with section 151 CPC. It was made under order 9 rule 13 CPC read with section 151 CPC. Lordship,
Indian Succession Act, divorce. Succession Act. What happened to will? Whether any,
probate proceeding is pending, she is also party there, my lord.
okay. Probate is pending
Pending.
in respect of the same property.
Say, no other properties in. She is also party.
And during the pendency of the succession is granted in respect of what debts and securities.
And money lying in the bank.
Money lying in the bank,
My lord.
which is not the subject matter
My
of the
lord.
will.
My lord.
Then you ought to have made your sister as party.
My lord, she was left out in the will, so my lord.
No, will is a different thing. Will takes care of landed property. What was bequeathed?
In all fairness, my lord, she would have been made party, while it was
Land.
not made party.
Only
Your
land.
lordship kindly see, she was not made party. My lord,
Where is the impugn order?
impugn order at page 54. My lord, the operative part is at page 60. From third line, my lord. Fourth line. Perusal of the said succession petition, it appears that the respondents herein mention themselves to be the only legal heirs of the deceased Amarendra Kumar Sharma, and thereby prayed to issue a succession certificate as stated above. In the said case, they submitted the death certificate of their deceased father, legal heir certificate, showing them only as legal heirs of late Amarendra Kumar Sharma. From the petition of the petitioner herein, it is quite clear that she is one of the living legal heirs of the deceased late Amarendra Kumar Sharma. As stated by the petitioner, she did not receive any notice in Miss Succession case number Iman. Even the respondents did not inform her anything about any such proceeding. From the pleadings of the petitioner, it further reveals that a huge amount of money and some assets have been connected in this case. As she is one of the legal heirs, she is also entitled to get a share of the debts and securities left by her father. As the respondents have not filed any objection against the petition of the petitioner, it remains proved that the petitioner has a good case and her petition is found to be reliable. Thus, I find sufficient force in the submission of learned counsel for the petitioner that the respondents fraudulently and willfully concealed about the existence of the petitioner as legal heirs of late Amarendra Kumar Sharma only in order to gain a succession certificate, playing fraud with the court. In view of the above facts and circumstances, I am of the considered opinion that the judgment and order dated 30/11/2021 needs to be set aside as the same was passed ex parte on the basis of the petition of the respondents herein, whereby the respondents plead fraud with the court and obtained sanction certificate. Accordingly, the petition is allowed. The judgment and order dated 30/11/2021 is hereby set aside. With the above view, the instant missed case is disposed of accordingly. Inform all concerned. My lord, this order could not have been passed because, my lord, kindly see, my lord, the application was made under Order 9, Rule 13 CPC. Lordship, kindly see Order 9, Rule 13 CPC says. Order 9, Rule 13. In any case in which a decree is passed ex parte against a defendant, he may apply to the court by which the decree was passed for an order to set it aside. And if he is satisfied, the court that summons was not the other thing, my lord. My lord, can you say there must be a decree? My lord, sanction certificate is not a decree. And my lord, she was not party, so no question of ex parte. So
You did not made her party.
but she was not party. So it is not a specific provision is there, my lord. Kindly see Indian Succession Act.
Revocation.
My lord. My lord.
What is this provision?
383 or appeal 384. So, my lord, this impugn order could not have been passed on this application.
But this order of grant of succession is liable to be set aside otherwise also.
My lord.
This application you have filed under 227, the instant CRP, 227 or 115. 115.
My lord, 115.
Otherwise, it is apparent that you suppressed the
Not suppressed, my lord. She was not given any property. My lord, your lordship has seen the will. My lord, the
will is a different thing, but she is your sister.
sister, married sister.
Married sister, but you cannot say that we are the only legal heirs. How can you say?
But how
When
in
your
this
sis-
application, my lord, it says civil procedure code, my lord, and the section certificate.
Order
In
9
civil
Rule
case, the
13 may
procedure
not
has
be.
to be followed, my lord. Procedure has not been followed.
Order 9 Rule 13 may not be applicable.
Order 9 Rule 13 is not applicable. Let them file a proper application, my lord. Let them decide along with the probate case, my lord. I have no objection. My lord.
No, probate case is not in question before this court now. Yes, what is your submission?
Let them file a
Lordship,
proper application.
Otherwise, my land senior friend has read the last portion. I just will trouble my lord to, if I may be allowed to read from page 58. What was the fact? They have intentionally suppressed about the existence of the sister. After,
No, that he is admitting.
Lordship,
that is-
after the succession certificate was obtained, when we came.
But you should have filed a application for revocation of this.
I will come to that. I will address that issue also, Lordship. After the succession certificate was issued, when we came to know about the same, we filed an application under Order 9. Thereafter, they came up with the so-called will, a fraudulent will was made, and they filed an application for order to deprive us from the order. Lordship, as far as the question whether Order 9 Rule 13 is applicable or not, may I, Lordship, may kindly I will rely upon the judgment of the Supreme Court, para 8 and 9. I will start from para 7. Lordship, may I read it? This
Yes.
is on the
Para?
same para 7. This is in respect of same Succession Act, and here also Order 9 Rule 13 application was filed And this is recent judgment of the Supreme Court. Your Honor.
Yes, please read.
Para 7. It is in the aforesaid circumstances that the matter has traveled up to us. Order 9, Rule 13 to state the obvious is an application made to set aside an ex parte degree. It is also a matter of record that they appear in the appeal preferred against the grant of succession certificate. The primary requirement of an application under Order 9, Rule 13 is whether the summons were duly served and whether there is sufficient cause that prevented the party from appearing in the court. It is an undisputed fact that the appellant number 1 was minor, aged about 12 years at the time when the respondent initiated proceeding for grant of succession certificate. A public notice was issued pursuant to the order of the learned additional district judge. However, the said notice did not clearly specify that the proceeding were initiated on account of death of so-and-so. The observation of the learned additional district judge by the order dated so-and-so to the effect that the minor could have, upon publication of the public notice, impleaded himself as a party and raised objection is wholly erroneous and perverse. Being a minor at the relevant time, the appellant number 1 was legally incapacitated from taking such step. Furthermore, the respondent were fully aware of the existence of appellant number 1 as one of the legal heir. Despite such knowledge, no steps were taken to ensure the appointment of lawful guardian to represent the minor in the proceeding. It is only upon attending majority that the appellant number 1 acquired the legal capacity to challenge the said proceeding and accordingly initiated the present action. There is nothing on record to suggest any collusion between the minor and his mother. Section 372 of the Indian Succession Act governs application for grant of succession certificate, where Section 383 provides for revocation of such certificate on specified ground. When an application is defective or material facts have been suppressed or misstated, the certificate issued pursuant thereto is liable to be revoked under Section 383 of the Act. The factual metrics of the present case squarely justified invocation of the said provision. Additionally, there are material discrepancies in the particular furnished in the original application. The mother of the minor, who is widow of late so-and-so, was incorrectly described as the wife of one so-and-so. No explanation has been provided for such a serious misstatement, nor is there any material on record stabilizing any connection between appellant number 2 and the said Jitendra Jain. This inaccuracy further vitiates the proceeding. It is also pertinent to note that the minor was never impleaded as a party in the succession proceeding, thereby depriving her of an opportunity to be heard. Para 9, Lordship. In the present case, the appellant filed an application under Order 9, Rule 13 after dismissal of the appeal. In view of the facts and circumstances discussed herein above, the application deserves to be allowed. The High Court, Lordship, here also Order 9, Rule 13 application was made. He was minor.
Order 9, Rule 13 application was made where? In
the trial court, because after attaining majority, she was not a party. The minor was not a party.
now what this appeal after dismissal of appeal? Which appeal it is referring?
The succession after succession certificate appeal was made.
Who preferred the appeal?
The appeal was preferred by the mother and the minor. And thereafter, after dismissal, we approached the trial court and then the minor filed an application to set aside under Order 9, Rule 13. Lordship, Para 10, I will read 10 also. Accordingly, the appeal is allowed. The impugn order is quashed and set aside. Consequently, the application under Order 9, Rule 13 is allowed. The ex parte order granting succession certificate is hereby quashed and set aside. The matter is restored to the original number. The parties are directed to appear before the competent court dealing with the succession certificate, proceeding on the date to be fixed by the court. So, Lordship, it can be cancelled under 383. My learned friend has correctly stated, but otherwise also Order 9, Rule 13 is maintainable, Lordship, because no service was made to me. I was not a party. And the learned court below has observed that fraud was played upon the court. They have produced the next of kin certificate wherein my name is not there. They have given a categorical statement that they are the only legal heir. They have obtained the succession certificate playing fraud with the court. And after we file an application to set aside that order, they came up with an will. That proceeding is pending. That initially that was dismissed on the ground of limitation. Then they are file and review that is pending. So this is a fit case where fraud has been played with the court, not to entertain the revision, Lordship.
Anything you want to say?
Well, this judgment is not applicable because it was after the appeal.
Maybe order 9 rule 13 application has been filed under the same set of circumstances.
Lordship has seen that the Honorable Supreme Court has found that the proper provision is section 383 Indian Succession Act. Section 372 of the Indian Succession Act governs application for grant of succession certificate, whereas section 383 provides for revocation of such certificate on specified ground.
Lordship, in
Whereas the
fact,
Supreme Court has held that the proper provision is section 383 Indian Succession Act.
Lordship, I will like to draw my Lord attention to 372(2) also.
It was the order 9 rule 13 application was made after dismissal of the appeal. So it is not applicable in this case. Let them file a proper application, let the learned trial court decide the issue. I have no objection.
That is not one of the ground in the revision, Lordship. That is not their ground. Where is that ground in the revision? I have not found that ground. This is not the ground of the revision, Lordship. And moreover, Lordship 372, may I read it? If the petition contain any averment which the person verifying it knows or believes to be false or does not believe it to be true, that person shall be deemed to have committed an offence under section 198 IPC. Lordship, they are liable for offence.
Go to the police.
Yes, you have committed an offense. Heard. Mr. This is item number
1.
heard Mr. K. Day, the learned counsel for the petitioner. Also heard Mr. G. Khandelia,
Yes.
the learned counsel for the respondent. This application, next para. This, please take your seat. This revision, this application under section 115 of the Code of Civil Procedure, 1900 has been filed by the petitioners Shri Poonam Kashyap Sharma and Shri Pritam Kashyap Sharma, impugning the order dated 13/11/2023 passed by the Court of Learned District Judge, Learned Additional District Judge within bracket FTC 2, Tinsukia, in Miss J case number 26/2023, arising out of missuccession case number 17/2021, whereby the succession certificate granted to the petitioner by the Court of Learned. Which court granted you succession certificate?
Additional district judge Tinsukia.
Additional district judge
FTC Tinsukia.
within bracket FTC Tinsukia was by its order dated 30/11/2021 passed in Miss Succession case number what was the succession case?
26 of 2023.
26 of 2023 was
No, set aside, it is 17/2023.
Was set aside. Stop. The facts relevant for consideration of the instant revision petition, in brief, are that both the petitioners are the sons of late Amarendra Kumar Sharma of village Naholia in Dibrugarh district. Stop. It is pertinent to mention herein that the respondent is the daughter of late Amarendra Kumar Sharma, and as such, the petitioners and the respondents are brothers and sisters in relationship. Stop. After late Amarendra Kumar Sharma expired on 27, no, after late Amarendra Kumar Sharma expired on 27/10/2020, and after his demise, both the petitioners had filed an application under Section 372 of Indian Succession Act 1925 for grant of succession certificate in respect of debts and securities left by their deceased father. Stop. In the said case was registered as Miss Succession case number 17/2021. Stop. It is pertinent to mention herein that the present respondent, who is the daughter of late Amarendra Kumar Sharma, was not made a party in the said case. Stop. Rather, it was pleaded in the application filed by the present petitioners under 372 of the Indian Succession Act 1925 that the present petitioners are the only legal heirs of late Amarendra Kumar Sharma. Stop. Next paragraph. Thereafter, by its order dated 30/11/2021, passed in Miss Succession case number 17/2021, the Court of Learned Additional District Judge within bracket FTC Tinsukia granted succession certificate in favor of the present petitioners. Later on, where is your application? The application filed by the opposite party.
Page 43.
Page
43, Lordship.
thereafter, next paragraph, thereafter, on 1/11/2023, the present respondent had filed an application under Order 9, Rule 13 of the CPC, read with Section 151 of the said code, praying for setting aside the ex parte order dated 30/11/2021 30/11/2021. You did not file any objection against this.
My lord, we file application for stay of the petition till disposal of the probate case.
Probate.
My lord.
Stop. However, by order dated, no, thereafter, by order dated, no, before that, itu cut off. On the basis of the said application filed by the respondent, Ms. J case number 26/2023 was registered. Stop. Thereafter, by order dated 13/11/2024, the Court of Learned Additional District Judge, FTC Tinsukia, had allowed the application filed by the present respondent and set aside the order dated 30/11/2021, whereby the succession certificate was granted to both the present petitioners. Stop. Mr. K. Day, the learned counsel, next paragraph. Mr. K. Day, the learned counsel for the petitioners, has submitted that the Court of Learned Additional District Judge Tinsukia has erred in setting aside the order dated 13/11/2024 on an application, on the basis of an application filed by the respondent under Order 9, Rule 13 of the Code of Civil Procedure, inasmuch as the present respondent was not even made party to the missuccession case number 17/2021, and therefore he submits that the question of proceeding ex parte against a person who is not made a party in the proceedings does not arise. He submits that since the Indian Succession Act 1925 contains a specific provision for revocation of succession certificate, the appropriate applicant, if certificate, if the present respondent was aggrieved with the issuance of succession certificate, she ought to have filed an appropriate application under Section 383 of the Indian Succession Act 1925. He submits that the Court of Learned Additional District Judge Tinsukia had erred in ignoring this aspect and ignoring this aspect while setting aside the order by which succession certificate was granted to the petitioners. He further, next para, the learned counsel for the petitioner further submits that after his death, the father of the present petitioner had also executed a will on 9th September. No, before his death, the father of the present petitioners had executed a will on 9th September 2019, wherein he had bequeathed his landed properties and shops in favor of the present petitioners, and nothing was bequeathed to by the deceased father of the petitioners to the respondent number 1 and to the present respondent on the ground that she got married long time ago and is living happily in her matrimonial home, and the father had already gifted her money earlier in the form of fixed deposit and insurance policy, as well as other valuable jewelries, and therefore he decided not to give her any share in the scheduled property, in the property mentioned in the schedule of the will. Stop learned counsel for the petitioner further submits that the present petitioners have also filed a probate case before the Court of Learned District Judge Tinsukia, and said case has been registered as probate title suit number. What is the
Lordship, that has not been registered. There was a condonation application was filed along with the probate. That petition has already been dismissed, and they have filed a review against that petition,
okay?
and that is pending.
Okay, no. Probate case. However, as there was delay in filing the said probate case, it was accompanied along with a delay condonation petition. Sublearned counsel for the petitioner submits that the delay condonation petition was dismissed by the trial court and a review is pending.
But I have no information on
I have the order. That is dismissed around 1 year back, Lordship. I have the order.
Continue. Last line. Last line, pardon. No. Continue with. However, continue. Taragot. To continue. তাৰপিছত last line পঢ়ো। Tinsukia, as such, they had filed an application before the Court of Learned Additional District Judge to stay the proceeding of Miss Case number
26 of
26/2023 till disposal of the said probate case. However, said prayer was not allowed by the Court of Learned Additional District Judge, and the succession certificate was revoked. Stop. The learned counsel for the petitioner submit that the petitioners may not have any objection if the respondent files an appropriate application before the appropriate court for revocation of the succession certificate, and in that, and if same is done, they may contest the said case. Stop. Under aforesaid circumstances, the learned, it is submitted by learned counsel for the petitioners that the impugn order dated 13/11/2024 is liable to be dismissed. It's liable to be dismissed. Stop. Next para. On the other hand, Mr. G. Khandelia, the learned counsel for the respondent, has submitted that the Court of Learned Additional District Justice Sukhya has rightly set aside the order dated 30/11/2021 passed in mis-succession case number 17/2021, whereby succession certificate was granted to the present petitioners as it is apparent from the impugn order that the petitioners played fraud upon the court and suppressed material facts from the court by stating that they are the only legal heirs of deceased Amarendra Kumar Sharma. He submits that in doing so, in suppressing the material fact before the court, the petitioners have also committed an offense under section 198 of Indian Penal Code, as indicated in section 372 within bracket 2 of the Indian Succession Act. He submits that though the respondent could have approached the court which issued the succession certificate by filing an application for revocation of the certificate under 383, under section 383 of the Indian Succession Act, however, the filing of an application for setting aside the order which was passed ex parte against the present respondent is also maintainable in view of the decision of the apex court in the case of Dipesh Maheshwari and another versus Renu Maheshwari and other reported in 2026 Supreme within bracket SC 332. He submits that in the aforesaid case, the apex court, under similar circumstances, had allowed an application under Order 9, Rule 13 of the CPC and set aside the ex parte order granting succession certificate to the to the succession certificate. In that case, stop. Any other submission?
Lordship, the initial order that is at page 22, that also speak that it is an ex parte order.
Page 22.
22. Case line number 3, has such the court has heard ex parte regarding the petition. Line number 3, Lordship.
He further submits that since the respondent being a legal heir of deceased Amarendra Kumar Sharma was not made a party in the Miss Succession case number 71 of 2021, and since the order dated and since the judgment dated 30/11/2021 passed in the said case was an ex parte order as indicated in paragraph number 7 of the said order, he submits that an application under Order 9, Rule 13 is maintainable in this case, and no infirmity is there in the impugn order. Hence, he prays for dismissing the instant revision petition. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. Stop. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. On perusal of the materials on record, it appears that there is no, though it appears that though the present petitioners in their application filed under section 372 of the Indian Succession Act before the trial court, on the basis of which Miss Succession case number 17/2021 was registered, have pleaded that they are the only legal heirs of the deceased Amarendra Kumar Sharma. However, the materials on record clearly indicates that the said statement is a false statement made by the petitioners in the succession certificate. Stop. In the said application. Stop. It is apparent from materials on record that the petitioner, that the respondent Srimati Karabika Kashyap Sharma is the sister of the present petitioners and daughter of the deceased Amrendra Kumar Sharma. Hence, she ought to have been made a party in the said succession case. Stop. The observations made by the Court of Learned Additional District Judge in the impugned judgment that the present petitioners fraudulently and willfully concealed the fact of the existence of another legal heir of late Amrendra Kumar Sharma, that is the present respondent, and as such it এই লাইন তো পড়াচ্ছেন আগৰ পৰা পঢ়ো No. We willfully conceal the fact of existence of a legal heir of deceased Amrendra Kumar Sharma in form of the respondent, who is his daughter, cannot be faulted with. Stop. The question, next paragraph. The question that as a specific provision is there in the Succession Act under Section 3 83 for revocation of the succession certificate, comma, the respondent ought to have preferred an application under the said provision. Also is not of much relevance in as much as the fact remains that the Court of London Additional District Judge proceeded ex parte against the respondent, present respondent in the succession case number, mis-succession case number 17/2021. And the and in light of the finding of the apex court in the case of Dipesh Maheshwari and another versus Renu Maheshwari and another Supra. It, wherein it was held that an application under Order 13, Order 9, Rule 13 of the Code of Civil Procedure is also maintainable in case in succession certificate is proceeded ex parte without making a legal heir a party to such case. Stop. In the aforesaid case, the apex court had quashed the succession certificate granted in a succession case which proceeded ex parte against the legal heir who was minor at the time of grant of succession certificate. As such, this court finds no fault in the impugn order whereby the succession certificate granted to the present petitioners on 30/11/2021 in mis-succession case number 17/2021 has been set aside. Stop. In view of the discussions made and reasons cited in the foregoing paragraph, this court finds no error, this court finds no grounds to interfere in the impugn order. Accordingly, this revision petition is dismissed.
Much obliged.
I may have to make some little corrections while break now.
My lord, in the previous item, lordship, in item number 5, on 5/9/11/9 it is fixed. Can it be on 14/9, my lord?
Item number 5.
Item number 5. Instead,
14/9.
oblige the lordship.
Item 2.
May it be, Your Lordship. Hello, this is an appeal against an order rejecting my prayer for temporary injunction. My lord, before I go to the impugned order, particularly the operative part, my lord,
Yes.
I'm just giving the background, my lord. What has happened? The petitioner was sanctioned a cash credit limit of around 1.6 crore, my lord, by the respondent bank before your lordship. It was in 2017.
What it means cash credit limit.
Cash credit is called CC limit. Cash credit limit means, my lord, if I want to start a business, I approach the bank, then I make an application for give me a loan, but entire amount of loan is not required at a stretch in the beginning. I want to take the loan in installments as and when I need, and after a specific period, maybe of 1 year of moratorium, they will ask me to give the EMI.
Okay.
No.
That will complete. So it may be 1 year, it may be less than that, maybe more than that. But so far as cash credit limit is concerned, at a time the loan is not taken. In installment, I'll take, but my limit is up to 1.6. Beyond that, I cannot take. We are not very much concerned with that aspect. Your lordship has asked and I have given the reply. So admittedly, I have taken the loan.
Okay.
And loan was taken by me for the purpose of executing a work order, my lord, issued by the Irrigation Department of Government of Assam. My lord, as per the plea taken by the appellant before the trial court, my lord, they could not.
Who went to the court?
Well, I have gone to the civil court, my lord.
Why?
And I'm coming to that. I'm just giving the background. So I failed to make the repayment.
Okay.
So my loan was declared as non-performing asset. And thereafter, the bank issued demand notice. Then they have taken possession notice. And then they went to the debt recovery tribunal. And the case number is OAS 506, it will copy to go to DDN 506 of 2019. And I've just prepared a one-page note for the convenience of some.
Yes.
Eta copy dekha debo diye. Asani? Read them around size. You will get the results. 2000, my serial number 5, Lordship says, seen my lord, possession notice was issued by the bank in respect of the secured asset because I have mortgaged my immovable property, my lord. Then serial number 6, 2019, my lord, they have filed, since I didn't honor, my lord, the demand notice, they have filed OA 506 of 2019, filed by the bank before the DRT Gauhati. Then sale notice was issued on 29th of September 2020. Then, my lord, their application was allowed on 25/2/2021. Thereafter, my lord, against the sale notice, Lord, shall kindly note, this is very important. Against the sale notice, we filed an application which is registered as SA 48 of 2020, my lord. This is important.
What
That was initially
what SA stands for?
possibly a surface application.
Securitization application.
It is under the Surface Act, my lord.
Okay.
My lord, this application we filed against the sale notice, basically, my lord. And this application was dismissed for default on 9/4/2021. Then they issued e-auction sale notice. Then, since my application 48 of 2020 was dismissed for default, I again filed a similar application, which was numbered as SA 40 of 2021, my lord.
Yes.
And in the meantime, my lord, serial number 12 with the cause of action for the present suit, they have affixed a banner over my property involved in the present title suit, my lord. Thereafter, on 9/3/2023, my second application, that is SA 40 of 21, was dismissed on merit this time, my lord. So my application against this sale notice now stands dismissed. Now, Lordship will kindly see this serial number 12 is the bank affixed banner over my scheduled property, which is the suit property in the present suit, my lord. Now, what has happened, my lord? There, next page, Lordship will kindly see. Next page. There are two properties mentioned, my lord. Sale deed number so and so. Area is given 3 Katha 18 Ganda, my lord. This was not mortgaged. Second is sale deed number so and so, 8 Katha 18 Ganda, this was mortgaged. In the instant suit, my lord, I have filed the suit in respect of the property not mortgaged. Now, Lordship may kindly turn to my memo of appeal, my lord. I have annexed the plaint. Plaint is at page 13. I'll be very brief, my lord. Page 13 starts.
Yes.
Paragraph 1 itself, my lord, in detail I have given. Third line, Lordship will kindly see 8 Katha 18 Ganda from top, my lord, in the middle.
Yes.
My lord, this property, I said, it initially actually belonged to my mother. We are two brothers, my lord. So 50% devolved on me, and remaining 50% which devolved on my brother, he sold to me. So I have become the owner of this entire land. These are all admitted fact, my lord. What I am now submitting, my lord, these are all admitted fact. So the entire 8 Katha 18 Ganda covered by Patta number 27 and Dag number 132 is the secured asset, my lord.
Where this land is situated?
Sinchar, my lord.
Okay.
Now, my lord, the Lordship will kindly see next page, page 15, my lord. In the first paragraph, it's paragraph 2, I have stated, applied for loan in Punjab National Bank, and for this he submitted a project report and filed an application, and the bank, after due verification, sanctioned the cash credit and one vehicle loan amounting to rupees 1.68 crore only for his contractual work. In the said loan, he himself stood as a mortgager of the said land measuring an area of 8 Katha 18 Ganda, this land which I have just now shown, my lord. Now, Lordship may kindly turn to page 16, my lord. Paragraph on top, my lord, paragraph 14, I have stated about that SARFACI application number 48 of 2020, which I have already submitted. Both applications were dismissed. Paragraph 5 is important, my lord. That subsequently the defendant bank issued e-auction sale notice dated so and so in respect of the mortgage property, that is land measuring an area of 8 Katha 18 Gandas, and the structure standing thereon, which was mortgaged by the plaintiff by depositing his purchase deed number so and so, as aforesaid. But this is important. Recently, on 30th of August 2022, the defendant bank affixed a banner with remarks that the property belongs to Punjab National Bank on the outer gate of the suit property described in the schedule below, measuring an area of 3 Katha 18 Gandas, covered by RS Pat number so and so, Dag number so and so, appertaining to Moja Kanakpur, Part 2, Pargona Barakpur, District Kachar, which was purchased by the plaintiff by a separate sale deed by deed number so and so dated 13/5/2008 of the Office of Sub Registrar from Debashish Sen with following boundaries. Now, this is the property, my lord, which was not mortgaged. Now, Lordship will kindly see the prayer at page 19. Page 19, my lord.
Yes.
A decree declaring that the plaintiff is the owner of the suit land having right, title, and interest over the same and confirmation of possession of the suit property as described below. A decree declaring that the property as described in the schedule below was not created mortgage with the defendant bank by way of deposit of title deed by the plaintiff or otherwise. And again, a decree declaring that the suit land was not mortgaged to the bank. Basically, my lord, my prayer is that this property is not mortgaged. You cannot proceed against this property and you cannot put the banner which you have put.
So out of two properties notified by bank,
My lord.
one you are not, you have.
No, I'm not disputing. I'm not disputing.
But the other one, you are saying that it was not mortgaged.
Not mortgaged. Now, my lord, what has happened? Learned trial court, Lord, shall kindly see. Trial court has passed the order which is at page 50, my lord. It starts from page 50. I will not read the facts which I have just now stated are all stated in the petition. But the operative part of the order is at page 60, my lord.
Yes.
Page 60, my lord, the second paragraph. I have already heard the learned counsel appearing for both sides. I have also gone through the materials on record and considered the rival submissions of both the sides. Perused also the photocopies of the documents submitted by both sides. It is apparent from the perusal of the case record that the plaintiff petitioner has challenged the surfacey action initiated by defendant bank before the debt recovery tribunal in surfacey application number 48 of 2020.
It is surfacey application or securitization application. What is the correct nomenclature?
Lordship, it is surface application, but it starts from securitization of asset and recovery.
Okay.
So it
Madam,
is securitization.
So it is surfacey application.
Whatever it is,
Same thing,
this application was filed by me against.
Under surface here.
My lord, this application was filed by me before the tribunal against the sale notice in respect of the property secured, which was mortgaged by me. Admitted position, my lord.
Okay.
And this application, let me read the full order, then I'll make my submission.
Yes.
Now, the property which has been alleged to be illegally and arbitrarily affixed with possession notice of OP Bank, against which an order of injunction is prayed for by the petitioner, the said property is under currently pending adjudication before the Debt Recovery Tribunal, Gauhati. And this here the learned court below has committed an error. Court was of the view that in 48 of two things, my lord, 40 of 2020 is pending and 40 of 2020 involves the property over which the banner has been affixed and which is not mortgaged. Admitted position, my lord.
40.
This 48 of 2020, this is an application filed by me before the Debt Recovery Tribunal against a sale notice issued in respect to the property over which security interest was created by me. That was
Mortgage property.
mortgage property. This is an admitted fact, my lord. And I have shown in my list of dates, my lord, that it has been already dismissed against me.
Yes.
And
Against that, you have not approached the civil court.
No, my lord. And I have filed the suit in respect of another property which belongs to me. That is my personal property.
And in respect of that, no surfacey application was filed.
Yes. First of all, I did not file any application in respect of that property. Secondly, my lord, they have also not yet proceeded against that property.
Okay.
Now the question is, my lord, this is the position, this is the order, my lord, lastly says, in view of the same, it is deemed fit by this court not to interfere with the Debt Recovery Tribunal. My lord, tribunal has not dealt with this property till now. And this fact is admitted by filing an affidavit in opposition before the Supreme Court. And they have said that this OA 48 of 2020 should be corrected by this court. And it should be read as OA 506 of 2019, that is the original OA of 2019. Which your lordship will find at running page 73, my lord. This is an admitted position. Now, my lord, the affidavit in opposition they have filed, they are saying that in terms of section 25 onwards of the Act, my lord. My lord, this Debt Recovery Tribunal Act is of 2000, sorry, of 1993.
Debt Recovery Tribunal Act, DRT Act.
My lord, this Act of Recovery of Debts to Banks and Financial Institutions Act 1993, which was the original name, that has been changed from 1st of December 2019 by way of an amendment. And with effect from that date, my lord, the new act is now known as Recovery of Debts and Bankruptcy Act 1990.
Recovery of Debts and
My
Bankruptcy.
lord, I have given a copy. My lord.
Yes.
This act may not be available. With the precision.
Yes.
My lord, I have taken a printout, it's a very recent one. Lordship will straightway turn to page 19, my lord. At the bottom, the page numbers are given in the copy I have given. Page 18, my lord.
Yes.
Page 18, in the middle, my lord, chapter 5 is there, recovery of debt determined by the tribunal. Lordship has got, my lord.
Yes.
Section 25.
Yes.
Modes of recovery of debts. The recovery officer shall, on receipt of the copy of the certificate under subsection 7 of section 19, proceed to recover the amount of debt specified in the certificate by one or more of the following modes, namely, A. Attachment and sale of the movable or immovable property of the defendant. A. Taking possession of property over which security interest is created or any other property of the defendant. Now, they are relying on this provision. They are saying that we are entitled to proceed not only against the secured asset over which security interest was created, but also any other property belonging to the defendant. They are absolutely correct, my law is very clear. They can proceed against both. Now, the question will be, my lord, if it is this plea, the question before your lordship is whether learned court below did not enter into all these questions, because this plea was not taken by them. Learned court below did not pass the order on this ground. Now, if it is a pure question of law, my lord, it can be raised here also. If they want to justify the order passed by the learned court below on this ground, if it is purely a question of law, they can always take the plea. But here, my lord, the question is, there are certain facts for which this is not a pure question of law so far as this case is concerned, my lord. And it involves certain facts for which, unless a plea is taken before the court below by amending the plaint and the objection they have, amending the written statement and the objection they have filed against the application for temporary injunction, whether this order which was passed by the learned court below without referring to all these things can be justified, or whether it will be an unreasonable order and come within the parameters of the grounds on which your lordship can interfere in exercise your lordship's power under order 43 rule 1R. That is the point.
Yes.
Now, what is the fact? Lordship may question me that what is the fact in, but law is very clear. Fact is, my lord, I have created security interest over a particular property. They have put up a sale notice. If they sell it and they recover the entire amount, on top of that, my lord, I had a fixed deposit of 40 lakhs. That also in the meantime they have liquidated. Now, if after selling the first property which is mortgaged, there is still stamp due, then only they will proceed against the other property.
Under this 25A.
Yes. 25A doesn't say that one after another. But the question is,
Power is there,
power is there, my lord. I'm coming to
but
that.
when to exercise that power?
That is number one. Number two, my lord, your purpose is, or your right under the act is not to sell each and every property, but to recover your amount.
Yes.
If after selling the first part, nothing remains due, or if you make a pleading, specific pleading in the suit, my lord, in a written statement that, see, we have taken a valuation of your property, first property,
And it
its
will not
value is
pay.
1 crore only. for remaining 60 or 70 crore, we have to proceed against that. So that is why you are putting a banner that it is a PNB property. They're facts, my lord. These are facts, which unless you plead, unless the learned court below is allowed to adjudicate whether the order which did not refer to all these facts, nor a plea was taken in the written statement or the objection against the temporary injunction, this order which did not refer to all these things can be justified on this ground alone, my lord. My lord, my second submission will be this one. My one that I got quote in here. I mean, there is one judgment, and our Supreme Court in an earlier judgment of 2008 said that they can proceed against both. But this specific question as to if there are two properties, if they proceed against one and they can get their money back, then whether they should proceed against the other or not is a question decided in this case. Lord, we will find at page, my lord, page number 9. My lord,
You can,
but the last paragraph, paragraph 38. Oh, citation of 2018 is party name Mohan Bhandar versus Vijay Bank. 2018 SEC online Karnataka 4266. Lordship may kindly turn towards the end, my lord. Last 3 pages. Last, yes, my lord. Third page from the end, my lord, paragraph 38.
yes.
In the light of the aforesaid discussion, this court proceeds to pass the following. Now, first Roman A is not important. Next page, my lord, Roman 2 is important. The respondent bank would be at liberty to sell the secured assets in accordance with law and shall in the first instance make payment to auction, attempt to auction, sell the secured asset, namely property in question, that is commercial building situated at so and so, and it would also be at liberty to simultaneously auction sell said building as a whole. 3, my lord. In the event of respondent bank being able to realize from the sale auction proceeds the extent of value certified under the valuation report dated so and so, it would be at liberty to issue the sale certificate to the successful bidder accordingly as it deems fit. 4, my lord. In the event of first petitioner participating in the auction and being successful in the bid, either in the purchaser portion of the building only, first petitioner shall quit, deliver, and hand over vacant possession of the remaining portion of the property to the secured creditor, bank within 1 month from the said date of auction, except to the extent it had purchased. Next, in the event of first petitioner not being successful in the auction despite offering it bid or does not intend to participate in the auction, first petitioner shall hand over vacant possession of all those portions of the building in its occupation to the respondent bank within 60 days from the date of auction. So, when this paragraphs make it clear that you will proceed, but you will have to see that if the first property after sale you are getting back the entire amount, then you have a right to proceed against the other property also. My only submission before this honorable court is that, my lord, these discussions, these deliberations will take place before the learned court below. And if learned court below comes to a finding that yes, your assessment of the valuation of the two properties are such that we have to go for both the properties, then it is all right, my lord. I cannot probably question. But if I succeed, because I have not got any right to meet this point we are taking for the first time before the Supreme Court. If I succeed in showing that, see, your valuation of the first property is not correct, this is the correct valuation, and you will get this much of value if you sell the first property, and you will get your entire outstanding amount from the first property itself. There will be no need to proceed against the second property. So these are all questions of fact, my lord. My submission before lordship is these facts were not taken by them as a defense in the written statement or in their application or objection against the temporary injunction petition. End of judgment. And your lordship is aware when repeatedly this judgment was referred to, that Wonderland versus Entox Limited. I just read 2-3 lines from there. This was a case of, my lord, injunction in a passing of action, my lord. A particular what do you call this? Tablet, my lord, calcium tablet was sought to be, there was an agreement between the parties, and subsequently one party possibly did not accept the agreement, and they rescinded the contract and they wanted to sell it themselves. Now the suit was filed by the respondent herein, and then objection was initially, since the Madras High Court has got original jurisdiction, the injunction was refused by the single judge of the Honorable High Court. On appeal, division bench granted the injunction. Then the matter went to Supreme Court, my lord. In this background, my lord, para 14, lordship will kindly see what was the observation. Para 14, my lord.
Yes.
The appeals before the division bench were against the exercise of discretion by the single judge. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its own discretion, except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored the settled principles of law regulating grant or refusal of the interlocutory injunctions. An appeal against an exercise of discretion is said to be an appeal on principle. Appellate court will not reassess the material and seek to reach a conclusion different from the one reached by the court below if the one reached by that court was reasonably possible on the material. The appellate court would normally not be justified in interfering with the exercise of discretion under appeal solely on the ground that if it had considered the matter at the initial stage, it would have come to a contrary conclusion. If the discretion has been exercised by the trial court reasonably and in a judicial manner, the fact that the appellate court would have taken a different view may not justify interference with the trial court's exercise of discretion. And I am relying on this judgment to show that in this case, the trial court did not exercise the power or discretionary power reasonably and in a judicial manner, because now it is an admitted position. The respondent before your lordship has filed an affidavit saying that yes, it is correct that for SA 48 of 2020 was not pending at this stage. Number one, my lord. Number two, that did not relate to the property which has been the subject matter of the suit, my lord. And that being the position, the learned trial court's order is absolutely wrong, my lord, and cannot be sustained. My submission before your lordship will be, they should be allowed to take this plea. Lordship will pass an order directing the parties to maintain status quo, and matter may be remanded to the trial court so that they can make amendment to their written statement as well as the objection filed to the temporary injunction, so as to take this plea so that I can also.
Is there any authority on
Madam,
section 25 AA that which empowers taking of possession of secured as well as unsecured assets? How it should be, in what manner it should be
for
exercised?
that, my lord, this is the judgment. Otherwise, there is another judgment of 2008 Supreme Court, my lord. There, Supreme Court says both the property they can proceed. So that is why my submission is, my lord,
Karnataka High Court judgment.
Karnataka High Court I have given here. It says you have to go one after another. But
No, here it has, what you have pointed out is what court has actually done in that case.
Yes.
You have not pointed out the reasoning that when two powers are there, how it should be exercised. You can, my query is,
Yes.
when the section 25 AA empowers you to
proceed against
all properties,
including personal property.
how that power may be exercised.
On that matter, specific judgment I could not lay hands on.
Your submission?
My submission is, my lord, it is absolutely clear, and possibly, my lord, lordship will accept that if there are two properties and your claim is such that by selling one property, your entire loan gets, my lord, liquidated, even this one court will not grant them to proceed against the other property.
That is the
Yes,
submission.
that is my submission.
Okay. We'll continue at 2.
My lord, I'll make one submission from this Karnataka High Court and I'll get that Supreme Court.
Today, my lord. It may be fixed on 25th August, my lord, because another similar matter is fixed on 25th, my lord.
Item number 13 and 14.
And 14.
Heard Miss U. U. Chakravarti, Leonard's Senior
Special Senior Railway Council.
Special Senior Railway Council, appearing for the appellants, has prayed for
My lord, in the item number 13, I am the appellant. In
appellant
14,
in
I am
item
the
number
respondent.
13, in 14 respondent
Respondent.
has prayed for listing these appeals on
25th August.
25th August as some similar matters are listed on this
25th.
said date before this courts. Also, Miss M. Sharma, learned counsel for the other side, who does not raise any objection. The prayer is therefore allowed, list accordingly, on 25th August.
My lord, in item number 13, there is one IA for the stay. Stay was granted by 99/1/2019 for the stay is granted till the returnable date. Later on, it was not continued and the case is fixed along with the link as a link case, MFA and the IA fixed for hearing, my lord. So, my lord, in the IA may be, in IA, my lord, the ST may be continued, my lord, till 25th.
Lordship.
We'll decide on 25th.
Yes.
You are not pressing for execution.
Yes, Lordship. It
They are
is
not.
disposal stage, Lordship. On 25th, it will be disposed of.
25th we'll decide.
Bless you.
Obliged.
May it be yours. My lord, I'm just, before going to that judgment, my lord, two things, my lord, my learned friend also made a certain statement. This cash credit, your lordship made a query, what is this cash credit?
Yes.
Actually, my lord, this is not defined anywhere specifically. Bank has got its some journal or something like that, they call it IIBL. There's a cash credit limit is a short-term working capital loan facility provided by a bank to the businesses. It allows the borrower to withdraw funds up to a sanctioned limit to meet day-to-day operational expenses such as purchasing raw materials, paying wages, or managing inventory, defining the principles and practice of borrowing by IIBF.
So in this case, the limit was 1.6 crores.
Yes.
Okay.
And secondly, my lord, this essay, your lordship was making a query. What is this essay?
Yes.
Essay actually stands for securitization application.
Securitization.
Right.
So everywhere it has been wrongly abbreviated as SURFACE
Yes.
application. It has to be.
SURFACE is the name of the act.
Actually, my lord, I have found one more thing, my lord. Once we read the judgment, we find is earlier all of us have been referring, even Supreme Court also in earlier judgments referred to the act as SURFACE Act, SURFACE Act. But SURFACE Act is in this judgment which I was referring of 2008. It is the NP Act, Supreme Court says.
NPA.
NP Act. In short, my lord, otherwise it is SURFACE Act only. And the judgment which I relied on, this Karnataka High Court, I'll just point out, my lord, I actually had to highlight the paragraphs, particular 2-3 words in that paragraph, those paragraphs which I read, my lord, to drive home the point that they have to first proceed against the secured asset. If your lordship goes to the last but one page of that Karnataka High Court judgment, once again, my lord, on top your lordship will find the respondent bank, as your lordship got it, my lord.
Yes.
On top, my lord, Roman 2. A respondent bank would be at liberty to sell the secured assets in the accordance with law and shall in the first.
What I was asking is, this is what the court ultimately did.
Yes.
on the basis of discussions made in the judgment.
My lord.
Whether inside, anywhere in the body of the judgment,
My lord.
any discussion has been made as to how this power under
No, 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 no. my lord.
25 AA has to be
No, my
executed.
lord. In fact, there was a tenant was inducted, and in that context, after discussing, the court said,
But your submission is that
yes,
as both powers are available
yes,
to achieve the purpose for which this power exists,
my lord.
first the secured asset should be
Put to sale.
put to sale and only thereafter.
Yes, because
Okay.
my lord, because it is it's quite a justifiable thing that after selling the secured asset, if you have got nothing more left to recover,
Then there is no
there is no need to
basis
go for that.
and
And-
no logic for.
My lord, here the problem arose because both of my immovable property are situated side by side.
Okay.
One is adjacent to the other, and they have put this notice on the other property, and I prayed for an injunction in respect of the other property which is not secured
Okay.
asset. That is my submission. How to do the one?
Yes.
So
yes.
that's my point.
May I please, Your Lordship? Your Lordship, in this case, the bank has proceeded
What is your name?
a per which
Oh, yes, A Parvez. Yes.
in this case, the bank has proceeded under two laws. One is Securitization Act and another is Recovery of Debts and Bankruptcy.
Yes.
So under the SURFACE Act, we have taken steps only against the secured assets, which was mortgaged with the bank.
Yes.
And we have also right to proceed against other personal property of the borrower if the proceed of the secured asset is not sufficient to satisfy the debts.
Yes.
Your Lordship will see the judgment passed by the Debt Recovery Tribunal in COA 506 of 2019, page 108 of my written objection.
There is, they mentioned, they can also proceed against this. The word also is there possibly.
Yes.
Now your Lordship will come directly to the order passed by the TRT.
Yes.
First, the defendant number 1 and 2 are jointly and severally.
Where are you reading?
Page 110, third paragraph. In the result, the present original application number 506 of 2019 is allowed with post as under.
Yes.
The defendant number 1 and 2 are jointly and severally liable to pay to the applicant bank a sum of rupees 1,61,45,292 with future interest at the rate of 10.60% per annum simple from 1/11/2019 till the date of full payment realization. Then, claim of the applicant bank has been kept alive on mortgage property. That is all that piece and parcel of land measuring 8 kattas and 18 kondas, 5.39 r, with RCC G+2+80 type building standing there on covered under RS Patta number 27 dark number 113 under Moja so and so.
This is with respect to mortgage property. Then your lordship will come. Page 111.
Yes.
The applicant bank is also entitled to proceed against the personal assets and property of the defendants towards recovery of the debt.
Where? Oh, yes.
Page 111,
4.
Roman 4.
But when the bank will do so?
Yes,
It is entitled, but when this power has to be exercised?
yes.
Suppose you by selling the earlier property.
Being a public institution, it will exercise its right to recover the property or any by selling any property.
No, any
Now,
property.
here in this case, what is happening? We had proceeded against the mortgage property. We have taken physical possession of that property. We have taken physical possession of that property. At that time, the plaintiff has forcefully entered the mortgage property. And since the property is adjacent to another property, he has filed the application suit before the civil court saying that bank has taken possession of the property which was not mortgaged, which is not the fact. And definitely only after selling the mortgage property we will proceed if the proceed is not enough to settle the dues of the bank.
Okay, so
This
you
is
are
what
also
it is.
not interested against the second property.
No, we are interested here, Lordship.
No, if you get your dues from the first property.
Why we will proceed?
Yes.
That is my case.
No, that's but if the injunction is granted, suppose if the injunction is granted against the property which is not mortgaged, and we fail to realize our debts by selling the mortgage property, definitely we have right to attach this property and sell it under the provision of TRT Act. If the injunction is granted, then the certificate will be frustrated. Then the recovery officer of the TRT would not be able to sell this property. Execution proceeding is pending before the debt recovery tribunal.
No, but now there is no order of exercising that power. In what order you will exercise that power? The law gives you wide powers that you can sell the secured assets also and unsell.
You shall sell it as per law and by following the procedure prescribed by the law.
Okay, got it.
And here the case is that the TRT Act itself provides procedure for protection of the interest of the party. If he is having any grievance, he can file his objection before the recovery officer. He has right. Because TRT is a special law. Civil court cannot. Section 18 of the TRT Act bars jurisdiction of civil court.
What it says, 18.
Section 18. section bar of jurisdiction, your lordship. On and from the appointed day, no court or other authority shall have or be entitled to exercise any jurisdiction, powers or authority except the Supreme Court and the High Court exercising jurisdiction under Article 226 and 227 of the Constitution in relation to the matters specified in Section 17.
What has been mentioned in section 17?
Section 17 defines the jurisdiction of the tribunal.
Tribunal.
Jurisdiction, powers and authority of the tribunal. A tribunal shall exercise on and from the appointed day the jurisdiction, powers and authority to entertain and decide application from the banks and financial institutions for recovery of debts due to banks and financial institutions. Without prejudice to subsection 1, the tribunal shall exercise on and from the date to be appointed by the central government the jurisdiction, powers and authority to entertain and decide application under Part 3 of Insolvency and Bankruptcy Code 2016. The tribunal shall have circuit setting so and so. So this tribunal is constituted to decide matters before above 20 lakhs, and present case is above 20 lakhs. And here the dispute is already decided by the tribunal, against which no appeal is filed by the.
No, they have not come against the order of recovery. They have come only with a grievance that the asset which is not mortgaged should not be utilized first.
As per certificate, we have power to sell the property if the proceed of mortgage property is not enough.
That I am not disputing, my lord.
If the proceed is, and if injunction is granted, then a bank would not be able to proceed against that. Admittedly, this property belongs to him. So if the bank fails
But
to.
every property has an estimated value. The property one, how much is the estimated value?
This property.
First property.
So
Because you're outstanding.
Say your lordship. It
You're
is around
outstanding.
1 crore, and in the year 2021 certificate is issued for rupees 1 crore 64 lakhs plus interest from 2019. Now it will come around 4 crores with interest.
And value of the property,
It is around 1 crores.
it remains same.
My lord, I have a
Okay.
I have annexed the valuation, page 107, my lord, 94 to 104.
No, valuation is there.
Yes, I have a annexed.
Page number?
Page number 94. Page number 94 of my editor officer. Yes, it is 2 crore 90 lakhs.
So it is more than the.
No, my lord. With interest, now the value will come around 4 crores.
No, 2 crore 19 lakhs in the year 2020.
Yes, my lord.
Now 6 years have lapsed.
But we are unable to sell this property.
No,
Even
that is a different aspect.
Sir,
He is not opposing that. He is saying that you sell that first property.
That is my case is very clear, man. If after selling the first property, my learned friend is also agreeing, they have got a right to proceed against the second, provided by selling the first one, they cannot get the full amount of dues.
So we have to decide how powers under section 25 AA is to be exercised.
My lord, 25 is very clear. 25A says personal property also can be sold.
Sold.
Question before your lordship is when? And for this matter, my submission is very clear and my learned friend was accepting. if after selling the first property, they say, first of all, there has to be some valuation of the first property as on today. If they say that present value is this much, we are not going to be able to recover the entire amount by sale of the first one. These things, what I'm saying is, my lord, all these things should have been placed and argued before the learned court
Considered by
below.
the trial court.
Yes, and they should have placed this material. So we also would have got an opportunity to say that no, the value is not as you are saying, the value is this much. So these are all, that is my submission.
We can do one thing, your lordship.
Yes.
Order may be passed by selling the mortgage, after selling the mortgage property, the bank shall proceed to sell the other property of the petitioner.
And my learned friend is asking as if it is his application. And it was our application before the learned court below.
Because this suit is filed only to frustrate the original certificate issued by the debt recovery tribunal.
Okay. Heard Mr. D. Majumdar, the learned senior counsel assisted by Mr.
C. Gogoi.
C. Gogoi, the learned counsel for the appellant. Also heard Mr. A. Parvez, the learned standing counsel for the respondent bank. Hearing concluded, judgment reserved.
All right.
Reserving the judgment. It does. 30 dB আছে না?
Deep property.
None appears.
May you please, your lordship. Lordship, I pray for timely passable of this matter.
You're for?
Respondents,
None appears for the appellant on call. Miss, what is your name?
A. Burman, on behalf of SP Chaudhary.
N. A. Burman, appearing on behalf of S.P. Chaudhary, is present. Since no one is present on behalf of the appellant, let this appeal be listed after a week on a date to be fixed by registrar.
Item 12.
The item may be passed over timing. The correct counsel is on legs. My lord.
Okay. Okay, after some time.
Item 18.
Hey, please, Mothership, the connecting counsel is not available.
Where is he?
Court 18. Oh, my lordship, if you may ring, can I just go and call him if he's available?
Yes.
If it's-
Okay. Okay, you may call.
Yes, my lordship.
What is the matter?
This appeal is filed by the insurance company on the ground that the age was taken by the Thanet tribunal as per postmortem report, but his age, actual age as per office document was more than that. So from that point of view, the relevant multiplier in this case would have been 11, but the London trial court had took it as 13. That is the first ground. And second ground, lordship, as his age was more than 50, so addition in the head of future prospects should have been 15%, but in this case, 30% was given. These are the main ground, lordship.
What documents
Lordship, may I read Lordship from judgment?
Yes.
Lordship, paragraph 23, page 15.
I was in code 80.
May I read Lordship?
Just,
Paragraph 23.
just a minute.
In his cross-examination, he testified that the date of birth of Kirut Chutia was 31/7/1960. Exhibit
Yes,
9
ma'am.
is the certificate issued by oil, which reference to the date of joining and the date of birth. Exhibit 9(1) is the signature of Sri Rana Dev Das, which is known to him. This witness has not affirmed that the rupees Iman was the net salary. So regarding Lordship, yes, this is the vital evidence. Exhibit 9, Lordship, is they are in the trial court record, Lordship. May I read, Lordship, the deposition of
Trial court.
employer?
Yes.
Today, I came to depose in this case on being authorized by Mr. S.K. Das, Senior Manager.
Deposition of?
Deposition of employer CW3.
Yeah.
Account Department, Oil India Limited, Duliajan. I know that this is Kirut Chutia, who was employee of Oil India Limited, and his designation was Assistant
Right.
Technician, Grade 3 Welding. I know that this is Kirut Chutia died on 19/9/2013 in a road traffic accident. At the time of his death, he was drawing salary of 1,01,555. The said amount is after deducting all necessary taxes and deductions. Senior Manager Shri S.K. Das has put his
Fancy.
signature on the pay slip, that is Exhibit 7. The date of retirement of Disease Kirut Chutia was 31/7/2020 as per the records. In every year, there is hike of 3% on the basic salary of the employees offenses, and Oil India ID of the disease was 98659. This is now Dr. Cross. I do not have any authority to make any hike in the salary of any employee of Oil India Limited. Salary slip is computer generated. The date in the salary slip are inserted manually. As per the service record, the date of birth of Kirut Chutia was 31/7/1960. Exhibit 9 is the certificate issued by Oil India in respect of his date of join and the date of birth. Exhibit 9 is the signature of Ranadev. 9(1) is the signature of Sri Ranadev Das, manager year. So these documents clearly prove that at the time of accidental death, he was about 53 years, 1 month, 18 days.
Why
So-
the tribunal did not take into
As
consideration?
as per postmortem report, it was considered.
No, why tribunal did not take into consideration this exhibit 9?
Tribunal had held that as per postmortem report, his age was sufficient. But postmortem report is only on assumption. Some doctor writes something on assumption.
And exhibit 9?
Exhibit 9 is in there. It is service particular. This is in the trial court
Yes,
record.
no, exhibit 9, on what basis the date has been inserted?
This is the service particulars given by Oil India Limited. That produced.
No, but somebody has to give the date.
Yes, Lordship.
This is not date of birth certificate.
This is
This is a survey, this is a certificate where date of birth is mentioned.
Yes, this is
And
the
it,
official record.
it,
This is the official record given by the department, Lordship. Exhibit 9. Service particulars. So it is the date of birth as per Oil India record. So this is to be taken into consideration. This is the document on the basis of which he, when he joined service, when he is going to retire, and everything is written here. And it is a vital document also. So on the basis of
why
this,
it was not considered by the tribunal?
tribunal had considered the age as per Postmortem report, Lordship. Then our submission, Lordship, postmortem report, age is only on assumption if doctor writes something, but it must be on the basis of official record, Lordship. Official record is here exhibited by the employer, Lordship.
No, on what basis? Dates are age is mentioned in the postmortem examination report.
That is, doctor always write on assumption, Lordship.
What assumption?
It's a postmortem report.
No, what kind of assumption?
In paragraph 25 of the judgment, that same page of 15, page 15, paragraph 25 of judgment.
Yes.
Exhibit 4 is the autopsy report, which clearly depicts that Kirut Chotia was 45 years at the time of death. So his service, on this basis only, learned tribunal had considered his age as 45 years. But age as mentioned in the postmortem report is only on assumption it is written, Lordship, but everything is written in his official record shows as Exhibit 9. When he was born, when he joined his service, and when he is going to retire. And this was exhibited by the claimant side in the learned tribunal below. Our submission is that age should have been considered on the basis of this Exhibit 9, Lordship. And when his age is 53 years, 1 month, such and such, then he is entitled to 15% addition in the future prospect head, and his multiplier will be 11 in place of 13.
Okay.
These are my main grounds. They have filed cross objection, so I will give it back.
Yes, Mr. Burman.
Hello, in the cross objection, Your Lordship.
Total cross objection.
Yes.
Cross objection.
Your Honor will find. Para 3. Para 3, page 5, Your Honor. May I read it, Your Honor?
Yes.
That the claimants cross-objector state that on the basis of evidence adduced by the claimants in the MSCT case so and so, the learned tribunal erred in law in not considering the appellant's gross salary at rupees 1,91,253 and deducted the leave encashment of 73,743 from this amount. Other deduction of rupees 89 so and so is also deducted. Thus, the net salary of the deceased was taken at only at rupees 27,000, with other deduction, professional tax, rent recovery, social scheme recovery, salary saving scheme, LIC, etc. The leave encashment could not be included within the net salary, but all other emoluments consist of personal pay, protected personal, so and so, cafeteria payment. These are all benefits under oil, my lord. Thereby, the learned tribunal, while considering the loss of dependency of the deceased, illogically deducted a considerable portion of income from the salary without considering the settled position of law that the amount paid to the deceased employee by the IOCL should include the amount contributed by deceased, that is Provident Fund, salary, saving scheme, and all other emoluments consisting of personal pay, protected personal pay, special increment, so and so. The compensation awarded by the tribunal
by considering the net salary of deceased at rupees 27,812 by deducting from the salary the other deduction under separate heading mention of the compensation awarded to a claimant is on lower side and without considering the wider concept of what income in the facts and circumstances. So my submission, my lord, your honor, the contribution made by the deceased during his survivorship, my lord, which includes the provident fund, my lord, and other portion of income, that forms part of his salary, my lord, as per Supreme Court judgment. That is also a part of salary. So that salary cannot be deducted by the tribunal while making calculation of his loss. Because your honor, entire amount, including provident fund, leave and these are all treated as income, my lord. And this has to be taken as into account as quantum of compensation, my lord, while making the calculation, my humble submission. And in that aspect, your honor will find.
No, what was your monthly salary?
Yes, I'm coming to that, your honor. Paragraph 22, your honor will find of the judgment. That is in my cross objection, page 18. Para 22. May I read, your honor? Regarding the quantum of compensation, CW3, who is the senior assistant accountant of Oil India Limited at Duliajan, exhibited the pay slip as Exhibit 3. He testified that Khirot Setia died on so-and-so in a road traffic accident. And he was drawing a salary of rupees 1,01,555 after deduction of necessary taxes and deduction. Senior manager, C so-and-so is the signature on the pay slip. The rate of retirement of Khirot Setia was 31/7/2020. Now, your honor, kindly come to next para 24. How the learned tribunal has made the calculation. I have carefully scrutinized the salary certificate of Khirot Setia. Exhibit 7 is the salary certificate of Khirot Setia for the period 1/8/2013 up to 31/8/2013. The gross salary is rupees 1,91,253. That is the amount, your honor. And Supreme Court says based on this calculation has to be done. Leave encashment of rupees 73,740 is deducted. Now the major portion, my lord, has been deducted, my lord, making the, my lord, income on a lower side. Other deduction of rupees 89,698 is also deducted.
No, why do you get leave encashment? Against what leave encashment payment is made?
Leave encashment, and these are all, my lord,
Whether on monthly basis you get leave encashment?
Yes, yes.
No.
Leave encashment actually paid after the, my lord,
It is
retirement
it is money
benefit.
given, monetary benefit given against the leave which was not availed.
Yes, yes.
So it has to be
It has to be deducted. It is not part of regular salary.
how this can be part of regular salary, leave encashment.
No, my lord, my submission is that not only leave encashment, now the learned tribunal, my lord, also deducted the provident fund and other allowances, which are also part of his emoluments, my lord.
Yes.
This is entirely, well, the total amount he received. And this is the amount which he spent for his family also. That is Supreme Court what says, my lord, that the amount what he get is also spent upon the family. So that total amount, gross amount has to be taken into account. But here, your Lord Honor, you only see the learned tribunal has deducted 89,698 other deduction, and come to a net salary of deceased was rupees only 27,812. And your Honor will see in para 24, other deduction had to be deducted because this amount include provident fund contribution. And Supreme Court said provident fund contribution is also a part of his income, my lord. Professional tax, rent recovery, social scheme recovery, salary saving scheme, and even LIC, my lord, that Supreme Court says that will also come, my lord. And such other deductions. The leave encashment cannot be included within net salary. All other emoluments consist of personal pay, protected personal pay, so and so, are included in the net pay. So, my lord, while deducting the other deduction amount, the major portion of the income would be lost, my lord. The major portion of income of the deceased would be lost, my lord. Now, my lord, the contribution made by deceased are also saving from his salary only, my lord. These are also from his salary. So on that point, your honor, the learned tribunal ought not to have done that, your honor, and further on this point, I'll make a judgment, your honor. Supreme Court in National Insurance Company Limited versus Indira Srivastava. Paragraph 7, your honor. Paragraph 7, 8 and 14 may be seen. I will read paragraph 7, your honor. Mr. Rao, however, submitted that apart from basic salary, contribution made by the employee should also be taken into consideration for calculation of the amount of compensation, inter alia on the premise that the same would have become payable to him at a future date, as for example, voluntary retirement, superannuation, etc., which would be beneficial to the entire family. It was pointed out that contribution towards provident fund, your honor will kindly note, provident fund, then life insurance corporation, gratuity, etc., are includable in the definition of income, within the definition of income.
Yes, that was the submission.
Yes, you're done.
What the court held.
Yes. Then your honor will come to para 8, my lord. Then I'll come to conclusion. The term income has different connotation for different purpose. A court of law having regard to the change in societal condition must consider a question not only having regard to pay packet the employee carries home at the end of the month, but also other parts which are beneficial to the members of the entire family. Loss caused to the family on a death of a near and dear one can hardly be compensated on monetary terms. Now, Section 168 of the Act uses the word just compensation, which in our opinion should be assigned a broad meaning. We cannot, in determining the issue involved in the matter, lose sight of the fact that private sector companies, in place of introducing a pension scheme, takes recourse to payment of contributory provident fund, gratuity, and other perks to attract the people who are efficient and hardworking. Different offers made to an officer by the employer. Same may be either for the benefit of the employee himself or for the benefit of the entire family. If some facilities are being provided whereby the entire family stands to benefit, the same, in our opinion, must be held to be relevant for the purpose of compensation of total income, on the basis whereof the amount of compensation payable for the death of the kith and kin of the applicants is required to be determined. Total amount, my lord. For the aforementioned purpose, we notice the elements of pay paid to the deceased. Now, Your Honor, you may come to the, I will skip para 10, 11, para 14. Para 14, Your Honor, will may I read? Similar view was expressed by learned single judge of Andhra Pradesh High Court in so and so, holding. In this background, now we will examine the present deduction made by tribunal from the salary of the deceased in fixing the monthly contribution of the deceased to his family. The tribunal has not even taken proper care while deducting the amounts from the salary of the deceased. At least the very nature of deduction from the salary of the deceased. My view is that deduction made by the tribunal from the salary, such as recovery of housing loan, vehicle loan, festival advance, and other deduction, if any, to the benefit of the estate of the deceased cannot be deducted, while computing the net monthly earnings of the deceased. These advances or loans are part of his salary. So far as house rent allowance is concerned, it is beneficial. Next page, Your Honor. To the entire family of the deceased during his tenure, but for his untimely death, the claimants are deprived of such benefits which they would have enjoyed if the deceased is alive. On the other hand, allowance like traveling allowance, allowance for newspaper, periodicals, telephone, servant, club fee, car maintenance, etc., by virtue of his vocation, need not be included in the salary while computing the net earnings of the deceased. The findings of the tribunal that deceased was getting rupees 1401 as net income every month is unsustainable, as the deduction made towards vehicle loan and other deductions were also taken into consideration while fixing the monthly income of the deceased. The above finding of tribunal is contrary to the principle of just compensation initiated by Supreme Court in the judgment in Helen's case. The Supreme Court in Concord of so and so held that determination of quantum must be liberal and not niggardly, since law values life and limb in a free country in generous scale. Now, this is para 15 and one such chart has been prepared of benefit. Now, considering all this, my lord, this appeal ultimately, Your Honor, para 19, Your Honor, may say, if the dictionary meaning of the word income is taken, para 19, Your Honor, if the dictionary meaning of word income is taken to its logical conclusion, it should include those benefits either in terms of money or otherwise, which are taken into consideration for the purpose of payment of income tax or profession tax, although some elements thereof may or may not be taxable or would have been otherwise taxable, but for the exemption conferred thereon under the statute. So, para 21 also, Your Honor, the assessment of damage to compensation, the dependent base so and so, so and so. Ultimately, Your Honor, The crux of the matter is para 22 of the judgment. Yet again in New India Insurance Company versus so and so, the same view was reiterated. However, therein, although the word net income has been used, but the same itself would ordinarily mean gross income. Your Honor will note that it's a gross income minus the statutory deductions. We may also notice that the said decision has been followed in New India versus Kalpana. The expression just must also be given its logical meaning, whereas it cannot be a bonanza or a source of profit. But in considering as to what would be just and equitable, all facts and circumstances must be taken into consideration. In view of our finding above mentioned, the appeal is to be allowed insofar as the High Court has directed deduction of medical reimbursement and tax elements on the entire sum, which according to the statute constitute income. But we decline to do so for two reasons. So and so, firstly, accident taken by so and so, so and so. So, Your Lordship, my submission is that provident fund income deduction mentioned in paragraph 24 by the Learned Tribunal, my lord, provident fund, professional tax, salary saving scheme, LIC, these are all part of the income and the benefit of which goes to the family members of the deceased. Then this should be considered by the ought to have considered, my lord. And even, my lord, 30% future prospect, that is also I am entitled to.
What is your submission regarding age? The official document shows that he was
50.
aged about 53. And it is your own document.
But the tribunal considered the exhibit for postmortem report.
Yes, that the submission of the council is that that was wrong approach. When
And
official,
that 45 years at the time of death. That
What-
too. That your, I leave it to your honor, but postmortem report says that he is above 45 years.
Okay.
But Learned Tribunal has not got into any such determination of age as per the formula laid down in Susma Thora's case.
what formula?
My lord, the formula laid down in Sarla Verma case, my lord.
What formula?
My lord, my lord, that multiplier formula.
No, multiplier is to be taken considering the age of the,
Yes, yes.
as your age was found to be 45 by the tribunal, it took multiplier of 13.
30.
But the submission is that as the actual age is 53 as indicated by the official document, the multiplier of 11 ought to have been taken. Do you have any counter submission?
That, my lord, I leave it to your lordship because
Okay.
that cannot be disputed in the facts, my lord. Because salary slip says 53. My lord.
Yes, Mr.
But my lord, future, my lord, this my submission in a cross appeal is regarding that, my lord. The tribunal has not considered the income, my lord. The meaning of the word income in a wider
No,
connotation.
that is okay.
Yes. It should include provident fund, LIC, and all other. That is the 27,812, and also leave encashment.
Yes, Mr. Soikia, what is your submission?
Lordship, there is a salary certificate which is exhibited as Exhibit 7. It is in the trial court record, Lordship. In that, Lordship, some submissions made by my learned friend that regarding some amount is not deductible, that I also agree as per Supreme Court judgment, Lordship. But, Lordship,
C1. In Exhibit 7.
Exhibit 7, salary certificate.
Yes.
Dear Lordship, in my humble submission, these some heads, these are not part of regular salary. So these are not payable as a normal salary. Lordship will see self-lease accommodation reimbursement in that head 8244. Self-lease accommodation reimbursement. This cannot be part of regular salary, Lordship. He leased some accommodation for which he got some amount.
Yes.
It is my humble submission that it is not part of the regular salary. Then there is Ascasia overtime. That is 8.0. That is overtime is not regular. He do not regularly do overtime job. So Ascasia overtime, there are two heads, 8.2, 8.0, 4.0. These are, let's say, not regular income. 1 month he does overtime, so in that particular month he gets those amount. Then leave encashment is, Lordship, this is huge amount, Lordship. Leave encashment is not part of regular salary. And housing park adjustment, this amount is park adjustment housing that I do not think this is part of regular salary, Lordship. There are several heads, and UMGA, it is written there, UMGA, 6,183. This also in my
What is UNGA?
UMGA, Lordship, I have checked in Google search, Lordship. It is written as Uniform Gifts to Minors Act, UGMA, Uniform Gifts to Minors Act, which so says, Lordship, it allows an adult, usually a parent or grandparent, to open a custodial account and transfer assets such as cash, stocks, and bonds as an irrevocable gift to a minor.
Oh,
So-
then that is from his salary.
Yes,
His salary he is depositing to benefit of
Yes.
some of it.
Yes.
That has to be included. That cannot be excluded.
That Lordship may look into that matter, Lordship.
Okay.
But other heads and plus, Lordship, income tax and professional tax, 39,464 income tax and 208 professional tax. Total 39,672 was his deduction from that head. Income tax and professional tax he is bound to make.
Just. Yes.
So, Lordship, I have to say his professional tax is, Lordship, 208 per month. And income tax, Lordship, 39,464. Is salary certificate source. These are to be deducted, Lordship.
Okay, heard, Mr. A.J. Saikia.
Interfere, my lord.
Yes.
Future prospect, my lord, I also rely on that. At least 30% I'm entitled.
No, he's saying your submission is 30%. His submission is if his age is to be regarded as more than 50 years, then only 15% future prospect addition would be there. Is not it, Mr. Saikia?
Yes, Lordship, Prononcity clause 61.3. .3 Prononcity.
Heard, Mr. A.J. Saikia. Item number? The learned counsel for the appellant. Also heard Mr. B. Burwa, the learned counsel for the respondents slash cross objector slash claimant. Claimants.
Respondent one,
Respondent number 1.
1, 2, and 3.
The respondents number 1, 2, and 3 in MAC appeal number 569/2022, as well as cross objector in cross objection number 52/2022. By this common judgment, this court proposes to dispose of the MAC appeal number 569/2022, as well as cross objection number 52/2022, as both arise out of the common judgment and award passed by the Motor Accident Claims Tribunal, Dibrugarh, in MAC case number 37/2016. In the MAC appeal number 569/2022, the appellant insurance company has impugned the aforementioned judgment and award same, which has also been impugned in the cross objection 52/2022. Both the insurance company as well as cross objector are agreed with the quantum of compensation awarded to the claimants by the tribunal. The insurance company is aggrieved. The insurance company's plea is that the quantum is on the higher side, whereas the claimant's plea is that the quantum of compensation awarded to the claimants is on lower side. The facts, next para. The facts relevant for consideration of the instant appeal as well as cross objection, in brief, are that on 17/9/2013 at about 6:30 p.m. one Kirot Setia was proceeding from Lengrai side towards his home at Padumini Gaon, on foot. He was walking on the left side of the Tingrai Tengakhat PWD road. At that time, one motorcycle bearing registration number AS06 G5794 approaching from the same direction and being driven by its driver in a rash and negligent manner hit said Kirotsuke from behind with a great force, as a result of which he sustained serious injuries on his person. Stop. The injured was immediately taken to Tengaghat PHC for medical treatment, and from there he was shifted to Brahmaputra Diagnostic and Hospitals, at Dibrugarh. Stop. However, on 19/9/2013, Kirot Setia succumbed to his injuries. Next para. After death of Kirot Setia, his wife and two sons approached the Motor Accident Claims Tribunal, Dibrugarh, by filing an application under Section 166 of the Motor Vehicles Act, claiming compensation on account of death of their husband/father. Stop. The said claim case was registered as MAC case number 37/2016. Stop. The insurance company as well as the owner and driver of the offending motorcycle appeared before the tribunal and contested the claim of the claimants by filing written statements. Stop. Next para. On the basis of the pleadings of the parties, the Motor Accident Claims Tribunal framed following issues in the aforesaid claim case. Quote A from page 12 of the MAC appeal. Stop. Next para. The claimant's side examined 3 witnesses, namely Miss Hirumani Setia, within bracket claimant number 1 as CW1, Shri Babul Barua as CW2, and 1 Shri Rubul Bora as CW3. The present appellant and the other opposite parties did not adduce any evidence to counter the claim of the claimants. Ultimately, by judgment and award dated Seven 8/2018, passed in MSC case number 37/2016. The Motor Accident Claims Tribunal awarded a compensation amount of rupees 38,15,068 only to the claimants, along with an interest at the rate of 6% per annum. Stop.
Proceed. MAC case number is 97, not 37. Somewhere it might have been written wrongly. 97/13.
Oh, in the judgment it is
No, Lordship, we have our copies, it is 97 written. I have also pleaded, it's a 97 of the 13.
97 of
13, 2013.
you come to page number 10 of the page number 10 of the
Page number
memo,
10 of my appeal memo, Lordship.
appeal memo.
It is clerical mistake.
It is wrong.
Yes. Then Lordship may come to page 8, Lordship.
8 and 9. We have verified that it's 97.
Nine. 9 also, Lordship, it is written correctly 97. Page 8 and 9 correct.
Oh.
10 is wrong.
Okay. Then change it. MSC case number 97/2013. And what is the date of the award?
Judgment 7/8/18.
The judgment dated
Judgment dated 7/8/2018.
18. That is okay. That is right. Calico. Stop the said judgment and award has been impugned by the parties in the instant make appeal as well as cross objection. Stop next para. Mr. A.J. Saikya, the learned counsel for the appellant, has submitted that the Motor Accident Claims Tribunal, Dibrugarh, while awarding the compensation to the claimants, has erred in taking the age, in assessing the age of the deceased at as 45 years at the time of his death, merely on the basis of entry made in the post-mortem examination report. He submits that the age mentioned in the post-mortem examination report is only on the basis of a rough estimation made by the doctors conducting the post-mortem examination report. So he submits that the tribunal has erred in not taking into consideration the age mentioned in the official document, which is exhibited by the claimants themselves as Exhibit 9. Stop. He submits that Exhibit 9 is the certificate issued by the officials of Oil India Limited, where the deceased was employed, and as per the said exhibit, the date of birth of the deceased, Kirot Setia, was 31/7/1960, and as such, on the date of the accident, the age of the deceased was about 53 years.
53 years, 1 month, 18 days.
53 years, 1 month, 18 days. He submits that consequently, the tribunal also erred in choosing a higher multiplier of 13, taking the age of the deceased at 45 years, as 45 years. Stop. He submits that considering the date of birth mentioned in Exhibit 9, the age of the deceased is approximately 53 years, and as such, the correct multiplier to be applied in this case for assessing the loss of dependency would be 11 as per Sarla Verma.
As per Sarla Verma, for the Pronacity also, clause 44.
You have Pronacity's judgment. You may take it back. As per the judgment of the apex court, in the case of no, you give the judgment. I'll find out. Judgment at the apex court in the case of National Insurance Company Limited versus Pranay Sethi and others, reported in
2017-16 SCC 680.
2017-16 680. He further submits that as the deceased was more than 50%, more than 50 years of age at the time of his death, the addition against future prospects shall have to be to the extent of 15%. Which case you are relying? 15%.
Pronacity,
Which para?
61 3, subclass 3, Roman 3.
क्या लिखा last line? %15 of the actual salary. Actual salary. Stop. He submits that the tribunal has heard in adding 30% of the actual salary towards future prospects. Stop. He further submits that the while assessing the monthly income of the deceased, the deductions which are not the part of regular monthly salary has been correctly not taken into consideration by the tribunal. However, he fairly submits that some of the deductions which are not statutory deduction may have to be taken into consideration while assessing the income of the deceased. In support of his submission, Pranay Sethi to stop. On the other hand, BBS, no? Okay, I'll reserve the judgment.
Statutory deposit may be returned with interest.
Okay. With interest?
With interest, there is some judgment we are getting. In all cases like this, in present cases, not interest.
Yes, because every deposit accrues interest.
Yes.
And further, I relied on one judgment of National Insurance versus India's Invest.
You give that judgment, mark the paragraph which you are relying.
I have given the copy.
Heard Mr. A.J. Sakya and Mr. B. Barwa. Hearing concluded, judgment reserved.
The quantum of income.
Okay. Remaining matters.
So item number 12. That will be fixed on next week, 27 of May.
27 is not, may not be possible. It will be listed by
Any other convenient date?
no dates. Registry will-
Item number 23, my lord, there is an interim order, my lord.
Interim order will continue. 23. Listing will be by.
My lord, there you go. Give you.